Okay. She should
Okay.
be on it. Okay. Just
Okay. Okay.
wait.
I think that is good. All right, good afternoon, ladies and gentlemen. Oh, excuse me, good afternoon. Good morning, ladies and gentlemen. My name is Judge Lal, and we are going to begin with our state all-purpose calendar. This is with the State Court of Fulton County. Just want to make sure courtroom 2 is absolutely empty. So,
We have clients, defendants in here.
oh, okay, sorry, the camera is a little off. I can only see the front 2 rows as you. So, as long as there's someone in there. And do I have my PDs in there too, Mr. Bartell and Mr. Coleman?
Yes,
There-
good morning, Your Honor.
Good morning, sir. Okay. As I was saying, this is our all-purpose calendar with the State Court of Fulton County for today, first day of August, 2024 at 9 a.m. I apologize for the delay. We are going to get started. This is a calendar for individuals who were recently arrested and booked at the Fulton County Jail. Their cases have been formally accused, and the bonds have been set and attorneys have been assigned. Today, we're going to get a status of the cases as to whether the individual defendant would like to accept a recommendation from the state and enter a plea, or whether they would like to enter a not guilty and have the case reset for a trial.
Okay.
In either event, if you are a defendant charged with one or more misdemeanor offenses, please remember that you have a right to remain silent. Anything that you choose to say during these virtual proceedings, your statements can and will be used against you. Please remember that these proceedings are not only recorded, but also live streamed. So if you have to say anything about your case, speak to your attorney and not open court. You have a right to an attorney. If you cannot afford one, one will be appointed to represent you. All right, now, with respect to the individuals who showed up on Zoom, I see a couple of iPhones and a phone number or a Cedric Walker. If you are not courthouse staff, if you are not an attorney, and if you are not a defendant, then please put your Zoom phone on mute and switch off your video. And when you hear the defendant who you're interested in addressing is being considered, then you can turn on your video and unmute yourself. All right? Again, if you're not courthouse staff, if you're not an attorney, and if you're not a defendant, please switch off your video and unmute yourself. Appreciate it. iPhone with many zeros, all right? And the lady in the yellow shirt, ma'am, are you with courthouse staff?
Yes.
All right.
My name is Selena. Yes.
Do you speak English?
Little bit. Little bit. No, no understand big English.
Okay. All right. Who is hosting? Mr. Jordan, Miss Champion?
Miss Lewis.
Oh, Miss Lewis, yes. Could we please mute the lady?
Yeah, I see 9760. I got
All right, thank you. Okay. Mr. Coleman, who do you have to address first? I have someone at South Annex.
That's Miss Hoda's client. We can go to position number 13. It is
13, okay?
Yeah, before we get started, Your Honor, I just wanted to ask Ms. Champion if she got all of my paperwork yesterday.
Yes, Mr. Coleman, I did.
Thank you.
No problem.
And sorry, Your Honor, can they place me in a breakout with South Annex? I haven't spoken with him.
Oh. Miss Lewis, I don't know who's the deputy at South Annex. Deputy at South Annex?
It's Sergeant Gibson.
Oh, yes, Sergeant. Could you please watch your screen? We're going to place you in a breakout room with PD Hoda Atay.
Yes, Your Honor.
Thank you. Miss Lewis, thank you very much. All right, position 13 is the gentleman seated next to Mr. Coleman. Would that be correct?
That's correct.
All right. This is Kwame. Am I pronouncing that correctly? Kwame Davis?
Quayum.
Quayum, okay. Quayum Davis, and Mr. Davis, your case number is 23 CR 004666E, in which you have a couple of animal rights violations, including 3 counts of tethering, no special permit for an excessive number of dogs, and a 1 count of cruelty to animals. Your Incident date is January 14th, 2023. And is that the only case? And Mr.
No,
Kwai?
Your Honor, he's also position 14 as well.
Yeah, well, he's got several. He's got 13, 14.
And then 15 and 16 are MTAs.
Yeah, and so the second case is 23 CR 4667E. Two additional counts of tethering from April 26, 2023. And then he's got two bench warrants.
Right, those are these cases. Those are gonna be non-pos, just he's entering pleas to the positions 13 and 14.
Okay. Mr. Davis, you've been advised of your right to remain silent, and your attorney is Mr. Coleman. And we are going to enter a plea hearing. So if you please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right. I know that lady in the yellow t-shirt wants to be addressed. I don't know why. Please unmute yourself. Or if anybody knows Ms. Mokeke or Mr. Coleman, if you know Spanish, you can chime in any moment.
I don't.
Fortunately, I do not.
Okay.
Do we know what case she's here on?
I have no idea.
That means what's her name?
Oh, yeah, but we're trying to figure out what case she's here on.
You know
I don't.
Trying to get her name.
Can you hear me, Your Honor?
Yes, I can, loud and clear. Okay. Well, if somebody can Google it and just put something in the chat to her, then we'll be able to address her. Okay. In the meantime, Ms. Mokeke, you have, are we only entering a global plea on 2 of the cases and null crossing the FTAs?
Yes, that is correct.
All right. And what's the global plea offer?
The global plea offer for position 13 for count 1, it is 12 months served 30 days, credit for time served 15 days, balance probated, BARC, and reporting to the Animal Cruelty Registry. The defendant cannot own animals or have animals in his household for 1 year, and it's a $300 fine. For count 2, tethering, it is going to be 12 months concurrent with count 1, a $250 fine. For count 3, the tethering, it is going to be 12 months concurrent with count 1, a $250 fine. Count 4 will also be 12 months concurrent with count 1 and a $250 fine. For count 5, the no special permits, it will just be 12 months concurrent with count 1.
All right.
For position 14, count 1 will be 12 months served 30 days, credit for time served 15 days. Balance probated, BRAC, and reporting to the Animal Cruelty Registry. Defendant cannot own any animals or have animals in his home for a year, a $250 fine. For count 2, it is going to be 12 months concurrent with count 1, a $250 fine. And
this case
position
is
14 is going to run consecutive to position. Yes, it is going to run consecutive to 23 CR 00466E.
So in a nutshell, up to 2 years probation with not allowed to own any pets and to pay off these fines.
That is correct.
BARC.
I'm sorry?
To do the BARC program, BARC?
Yes, Your Honor.
I cannot remember what the acronym stands for, but I know it's something to do with animal ownership. And okay, yeah. And Mr. Coleman, are these the terms to which your client has agreed?
It is, Your Honor. We would ask that the court accept the plea as negotiated. We will request that the probation would either terminate or go non-reporting once he's completed the condition and paid the fines.
Okay.
We'd also ask that the probation fees be waived for a period of time.
And do you stipulate to the factual basis, venue, and ID for both cases?
Yes, Your Honor.
Okay. Ms. Mokeke, I'm not inclined to place probation on non-reporting considering the number of charges and the short time frame for both cases, but I'm willing to waive probation fees. Does the state have any comment?
The state does not have any objection to waiving the probation fees, but we do agree that we would prefer the probation to not go non-reporting.
Anything else, Mr. Coleman?
No, Your Honor.
All right. I will waive probation fees for up to 6 months for the first year, but then he'll have to continue to report to probation until the remainder of probation is completed, and he will need to start paying probation fees 6 months thereafter. Would your client still like to move forward?
You still wanna, yes, Your Honor.
Okay. Mr. Davis, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings in both your cases?
Yes, ma'am.
Is anyone forcing you or inducing you to accept this offer?
No, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your attorney to confront your accuser, challenge the evidence brought against you, to be able to present any arguments, defenses, and mitigating factors if you choose to do so, and have the state carry the burden to prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to, in position 13, case 23 CR 4666F, 1 count of cruelty to animals, no special permit for an excessive number of dogs, and 3 counts of tethering?
Guilty.
How do you plead to 2 counts of tethering in case 23 CR 4667E?
So I would say guilty.
With respect to position 13, count 1 is 12 months to serve 30 days, credit for time served 15 days. Your jail time is concluded. You will report to probation on Monday, and that will be before 3 p.m. I will waive your probation fees for up to 6 months, which would be August, September, October, November, December, January, which means you start paying probation fees in February 1st, 2025. While you're on probation, you will report to the, to the Animal Cruelty Registry. And I mean, in other words, these cases will be reported to the Animal Cruelty Registry. You will complete the BARC program, and you must enroll in that program within 30 days of being released. Let me see, at your expense. You are not allowed to own any animals or any pets for up to 2 years. Do you understand, sir?
Yes, ma'am.
And you will continue to report to probation. For count 1, your fine will be $300. Count 2, which is to run concurrent to count 1, is an additional $250 fine. Same for count 3, same for count 4. Count 5 is going to be 12 months concurrent with count 1. So for position 13, your total fine is going to be $1,050, which you would have to pay during the course of your probation. With regards to position number 14 on count 1, is going to be 12 months probation to run consecutive to the position 13. And it will be the same conditions, being on the Animal Cruelty Registry, completing the BARC program, with an additional fine of $250 and not allowed to own any pets. And count 2 is concurrent to count 1 with an additional $250 fine, which means that's an additional $500 fine. Your total fine for both cases is going to be $1,550 plus court costs and surcharges, as well as probation fees, which will start on February 1st, 2025. Failure to comply with these conditions can result in probation requesting a warrant for your arrest and you to serve out the rest of the time in jail if you violate any of the conditions of these bonds, of this sentence. Do you have any questions, sir?
No, ma'am.
All right, that concludes your sentence. Thank you.
Thank you, Your Honor.
Oh, and the bench warrants are null prost.
Next, we can go to position number 4, Mr. Banks.
Mr. Coleman, is this still a non-negotiated plea?
It is, Your Honor.
All right. This is State versus Alfred Banks, 24 CR 32Y. Mr. Banks is accused of battery, family violence, and criminal trespass causing damage to property from September 9th, 2023. Does he have a new arrest or a bench warrant?
Not that I'm aware of.
Okay. Mr. Banks, you've been, as I said, you've been advised of your right to remain silent, and your attorney is Mr. Coleman. This is going to be a non-negotiated plea, which means that the state is going to make a recommendation and allocate the factual basis for why they're seeking that recommendation. And your attorney is going to give me an alternative recommendation. I will let you know which option I'm going to select, keeping in mind I also have the option to disregard either recommendation, enter a not guilty plea, and have the case set for trial. Do you understand, sir?
Yes.
Please raise your right hand. Do you solemnly swear and attest that the testimony you provide will be the truth for purposes of this plea?
Yes.
All right, you need to speak up, sir.
Yes.
Thank you. Ms. Mukeke?
Yes, Your Honor. So officers arrived to the incident location on the day of the incident, September 9, 2023, in response to a domestic dispute call. They met with the victim, Jonah Turner, who advised that she had broken up with her boyfriend, the defendant, prior to this incident, and he refused to accept it and kept coming to her door night after night to get her to forgive him. On the night of the incident, the defendant broke into her bedroom window and destroyed her room when she asked him to leave. The defendant pulled her off the bed, which caused her to hit the floor and caused lacerations to her hand, her arms, and her legs. The parties had lived together for about 7 months prior to this incident. The defendant does have 21 arrest cycles, including a 2024 simple assault, a 2022 battery family violence, 2 counts of that, criminal trespass and theft by taking, as well as a 2019 battery where the time had expired, and a 2017 cruelty to children where time had expired on that case as well. Given the facts of this particular case and the defendant's history, the state's recommendation for count 1 is 12 months to serve 90 days, credit for time served 22 days, balance probated, no further contact with the victim, Jonah Turner, stay away from the incident location, and FVIP, 40 hours of community service, and no firearms. For count 2, that is going to run concurrent with count 1, and it is going to include just the stay away, of course. I would ask the court to sound for the victim as Jonah Turner.
All right. Ms. Jonah Turner, if you are on Zoom, this would be a good time to unmute and start your video. All right. Mr. Coleman, what is your client's recommendation?
Your Honor, I'm just requesting that the court sentence Mr. Banks to less than the 90 days that the state is requesting. Speaking with Mr. Banks, he is 32 years of age. He is a lifelong resident of Atlanta, Fulton County. He is a high school graduate. Before he was incarcerated, he was employed at Fins and Feathers restaurant as a dishwasher. I'm hoping that he is going to be able to return to that job once he's released. He is the father of 1 child. However, that child is now presently residing in the state of Tennessee. Again, I'm just asking that the court sentence Mr. Banks to less than the 90 days that the state is requesting. I prefer that he not be sentenced to the DVIP, but again, I understand what the charge is, and that unfortunately it is necessary that he complete in that program, participate in that program. But I am asking that the court also drop the 40 hours of community service.
On what grounds, Mr. Coleman, given the egregious nature of these allegations, this is tantamount to almost a stalking allegation. The victim is not here, so I don't even have her input.
Well,
I'm really concerned about this gentleman's attempts to try to reconnect with the victim.
Speaking with Mr. Banks, he states to me that he was in a relationship with the alleged victim for about 1.5 years, but it's been several months since they've had any contact, and he obviously does not intend to have any further contact with her.
Is the state aware of this other case? I'm trying to pull it up right now. 24 CR 004622Y, in which he entered a plea to simple battery. And did that involve the same victim?
I will go look into that right now. And it was 24 CR 004622Y.
No.
Looks like Mr. Banks just entered a plea a few days
No, that
ago
was
before
a
Judge Morrow.
different victim.
Okay. Mr. Coleman, given the nature of your client's criminal history record and given this recent case and the egregious nature of these allegations, I am going to go with the state's recommendation. And he will be required to report to probation every month and complete these conditions. I'm assuming, I don't know, what was the plea? Was he required to do DVIP as well in the prior case?
No, in that case, it was a random individual at a store that he got angry with and threw a Sprite can at him.
Would
So
the
he did
court,
not need to do an FVIP for that.
All right. Yes.
would the
So
court at least be willing to suspend some of the probation fees?
I will be willing to suspend the probation fees for up to 3 months, which is August, September, and October. He would need to start paying probation fees from December 1st, 2024.
That's agreeable, Your Honor. I did submit a plea form on this.
Oh, no. I'm so
as-
sorry. I miscoded. He'll need to spend additional jail time, so it'll be 3 months from the time that he is released. I do beg your pardon.
Yeah, he will have to serve an additional 23 days. I did submit a plea form. I did leave the number of days blank on there for someone could just write in 90 days.
Okay. Ms. Champion, do you have the paperwork from Mr. Coleman?
Yes, ma'am, I'll put it in.
All right.
Thank
And
you.
Mr. Coleman, if your client, I've already told you my option, your client is agreeable to the state's terms.
1 second, Your Honor. So basically, it's gonna
Please
go-
mute your screen if you're going to discuss with him. Ms. Champion, is Ms. Atay still in the breakout with her client?
She is, Judge.
Oh, not Ms. Champion, Ms. Lewis, excuse me.
Yeah, she still is.
Oh, okay.
No, I finished speaking with him, but I don't see South Annex on.
Oh, they may not came out. Let me kick them out.
Okay, just wondered. Thank you.
Your Honor, speaking to Mr. Banks, he is agreeable. We can go forward.
All right, Mr. Banks, I'm sorry, Mr. Coleman, do you stipulate to the factual basis, venue, and ID?
We will so stipulate.
All right. Mr. Banks, have you consumed any medicine or alcohol recently?
No.
And have you understood what's been going on in this case, this particular case so far?
Yes.
And are you satisfied with your legal services?
Yes.
Is anyone forcing you to take this plea today?
No.
And are you doing so freely, willingly, and knowingly?
Yes.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to confront your accuser, to be able to challenge the evidence brought before you, to have the assistance of counsel to present your arguments, defenses, and any mitigating factors, and also have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes.
How do you plead to 1 count of battery, family violence?
Yes.
How do you plead to 1 count of criminal trespass causing damage to property?
Yes.
Could you repeat that last one, please?
Yes.
I'll accept your guilty pleas to both these charges. With respect to count 1, it's going to be 12 months to serve 90 days, credit for time served 22 days. You have 23 more days to serve at the Fulton County Jail. Once you've completed this additional jail time, you will be released, but you must report to probation immediately on the first available business day, which will be Monday, Tuesday, or Thursday, and you must report before 3 p.m. Your probation fees will be waived for the up to the first 3 months, and then after that, you would need to start paying probation fees. While you're on probation, you will have no contact with Jonah Turner. You're to stay 200 yards away from this person and not communicate with her in any way, form, or manner, including any electronic devices or even on social media. You're to stay away from 671 University Avenue in Southwest Atlanta. You are to enroll in a domestic violence intervention program within 45 days of being released. You will attend all classes for the domestic violence program at your expense. While you're on probation, you will also complete 40 hours of voluntary community service with any nonprofit agency that's not a church and not a school. You must begin with a minimum of 10 hours per month, and then thereafter you shall complete 5 hours, a minimum of 5 hours every month until all 40 hours are completed. At no time shall you possess or be anywhere near a firearm. On count 2, criminal trespass causing damage to property, that will be 12 months concurrent with count 1, and to stay away and have no contact. That concludes your sentence.
Thank you, Your Honor.
South Annex, who do we have?
Hi, how you doing? Tedrick Whitish, ma'am. How you doing?
Fine, thank you. Ms. Atay, could you repeat your client's last name, please?
Whiters. And this is going to be a negotiated plea. Yes, that's right. 49.
This is Tedrick Whiters, case 24 CR 1348C. Mr. Whiters is accused of criminal trespass from March 21st of this year. Mr. Whiters, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Ms. Atay. As this is a negotiated plea, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Ms. Falk, good morning. And
Good morning, Your Honor.
what's the recommendation for this gentleman?
Yes, Your Honor. The state's recommendation is 12 months served 6 days, credit for time served 3 days from March 21st to March 23rd of 2024. Balance suspended. Stay away from the hotel located at 355 Peachtree Street Northeast. The name of the hotel was accidentally cut off, so let me just pull that up really quickly.
Either the
The
Hilton.
hotel's name is the Commons at Imperial Hotel.
Say that again?
The Commons at Imperial Hotel.
Okay,
It's actually an apartment building.
okay.
The state would ask the defense to stipulate to venue, factual basis, and identification for the purposes of the plea.
Okay. Ms. Atay, does your client accept these terms, and do you so stipulate?
Yes, we stipulate and he does accept those terms, Your Honor.
Mr. Whiters, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what's going on in your case?
What did she say? Time served?
Well, I guess that's the part that's important to you. Yes, that's what she said.
Okay. Yes, ma'am.
But did you hear the other important part?
What's the other important part?
That you cannot return to this hotel.
Oh,
Otherwise,
yes.
you'll be back with us again.
Oh, yes, ma'am. I won't go to the hotel anymore, ma'am.
All right, that's the more important part.
Yeah.
Okay. And are you satisfied with your legal services?
What do you mean by that?
Well, you were speaking with your attorney, Ms. Hoda Atay. Do you remember that?
I'm saying no, I'm not gonna get no probation. I'm not on probation
You
anymore.
are absolutely right.
I'm just gonna get time served, right?
Okay. Do you remember the attorney who was talking with you?
Yes, ma'am.
All right. Did she do a good job?
Yes, ma'am.
Okay. And Mr. Whiters, if you decide to plead guilty to criminal trespass and get time served, you would have to give up your right to go back to court and have a trial. You will not get a chance to confront your accuser, to challenge the evidence that would be brought against you, and have the state try to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights? You need to tell me yes or no.
But look, Miss Lau, but I'm saying like I won't have to if I take the charge, I'm not gonna have to do no more days in jail, am I?
That would be correct, but you will
On
give,
this,
but you
on
won't get it. Go ahead, Ms. Tate.
I'm sorry, yeah, we did speak about this, so you won't have to do more days on this. Now, you know you're held on something else.
Oh, yeah, I know about that, yeah, that's cool. I'm
Yes,
finna get
no
that.
more days for the criminal trespass.
Okay, cool.
Do you want a trial or are you willing to give up your right to a trial?
I give up I'm scared, I'll take the charge, I plead guilty.
I'm going to construe that as his formal waiver of his constitutional right to a trial. Do you agree, Ms. Tate?
No, I don't wanna go to trial, no
Yes,
trial.
Honor, it's a negotiated plea.
Understood. All right. How do you plead to one count of criminal trespass at the Commons at Imperial Hotel on March 21st?
Guilty,
Excuse me.
but
Yep.
I wasn't inside, they just pulled up and just jumped out on me. I was outside with a lot of dudes, they just free picked me. I wasn't doing anything, Mr. Like, that was crazy, they just approached me and say, I can't be in front of the hotel because I look like a non-Wells drug. Yeah, they just free picked me.
Mr. Whiters, you're not being held on this criminal trespass charge. If you don't want to plead guilty, you don't need to plead guilty.
Okay,
It's up to you.
yeah, okay. Now I plead guilty so I can go on and get this over with. No probation, time served, yes, I plead guilty.
Okay.
Your sentence is 12 months to serve 6 days, credit for time served 3 days, balance suspended. There is no additional jail time for this case. And you must stay 200 yards away from the hotel known as Commons at Imperial Hotel, 355 Peachtree Street in Northeast Atlanta. 200 yards away means the length of 2 football fields. You cannot be on the sidewalk, you cannot be at the parking lot, you cannot be in front of the hotel, you cannot be near the hotel. If you
Okay.
are seen at the hotel, you will be arrested again and brought back to jail. Unfortunately, you still have you have another case, so you'll have to address that separately.
Okay.
Thank you. Thank you, South Annex. Courtroom 2, who do we, sorry, the deputy in courtroom 2, where should I go next?
You can go to
Good
AC.
morning, Judge Lobb. This is Francois. I have a Ms. Brown,
You can go to AC.
All right.
positions number 7 and 8.
Thank you, Deputy Francois. South Annex, do we have any other cases? Otherwise, Miss Lewis, can we stop the video, please, for South Annex? We have Marquita Brown at ACDC. Ms. Brown, you've been advised of your right to remain silent, and your attorney is going to be Mr. Coleman. No, Miss Ate.
Yes.
And Ms. Brown, on position 8, is accused of battery, family violence from February 3rd, 2019. She has a bench warrant, 24 FTA 976. Position 7 and 8. I don't have an announcement. Ms. Ate, what's the announcement?
Yes, Your Honor, it's a non-negotiated plea. I mean, it's a time served offer. The only issue is, this is an incident from 2019, and she has spent, and she's getting credit for 72 days, so she has spent, you know, this time and last time, 72 days in custody. Well, it's just the terms of the probation that is the issue.
All right. Ms. Brown, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. This is going to be a non-negotiated plea, which means that the prosecutor is first going to give me a recommendation, and then your attorney is going to give, well, she just did her recommendation, and then I will let you know which recommendation I'm going to select, keeping in mind that I have a right to disregard either one and have the case set for trial. Ms. Mukeke? Oh.
Yes, Your Honor. So officers arrived at the incident location on the date of the incident and met with a Byron Keith, who stated that his girlfriend had locked him out of the house and threw all of his belongings outside. The victim did state that he believes the defendant suffers from MH. The victim showed officers his lease that stated that, his lease contract wasn't up until the end of the month. And then officers met with the defendant, who was extremely irate at the time. And they told her that she couldn't just kick the victim out and that he was allowed to stay there. Officers had the victim place his items back inside the home, and he said that he was okay from there, so officers left. Later, officers received a call from the victim again, stating that the defendant had bitten him. The victim did show officers bite marks on his upper back behind his right armpit. The victim told officers that the defendant must have bitten himself, and the defendant told officers that the victim must have bitten himself. The victim, Mr. Keith, told officers that the defendant was upset because he was warming up food and she didn't want him to eat it. The defendant does have 16 arrest cycles, including a 2014 ag assault where time expired. She does have a 2023 disorderly conduct conviction where she pled nolo. The state's recommendation is 12 months to serve 44 days, of course, credit for time served 72 days, balance probated, stay away from that incident location, which is 1638 West Lake Court Northwest, no further contact with the victim, Byron Keith, and FBIP, and no firearms. Of course, that FBIP is necessary because this was a family violence battery. I would ask the court to sound for the victim, Mr. Byron Keith, if he is on the Zoom.
Mr. Byron Keith? Just to clarify, the 72 days that she was incarcerated, that would be 1 day from 2019, and then I gather
71 days from 2023 when she had her first bench warrant. And then she was arrested, she was incarcerated from February 3rd, 2019 to March 6th, 2019.
Oh, okay. So that would be about, well, what, about 33 days?
Yes, and then she was incarcerated again from September 22nd, 2023 to October 16th, 2023.
So that was about 39 days.
And then from July 18th to
Oh, I see. Okay. So, all right, understood now. I was just trying to figure out why she was in custody for that long, but she's had 2 bench warrants in these cases. In this case, excuse me. All right. Ms.
Your Honor, thank you. And she is ready to put this behind her. It is from February 2019. She is 54 years old. She's lived in Georgia all her life. She does work as a medical technician in a radiology department, and she started training for that since she was 19 years old, Your Honor. She doesn't have a lot of violent history. I don't think she has any. I didn't see the pretrial report, but I don't think she has any significant history. She does live on her own. She lives in a hotel, or she was living in a hotel, and she expects to be able to go back there. She works full-time. She has done anger management since then. I think while she was on pretrial, she did do anger management. Because of her very little criminal history and the fact that this is from 2019 and she has done anger management, I would just ask for the balance of probation to be suspended. Of course, stay away from that address and no further contact with this person is fine. And I would ask, instead of FBIP, she could submit her anger management that she's already done. Or instead of FBIP, which is very costly, just more anger management, nothing further.
Ms. Atay, I'm afraid anger management is not a program for these kind of cases. I'm not certain what's going on with Ms. Brown, but pre-trial, if I'm just trying to see who's here. Ms. Tyson?
Yes, ma'am.
May I have a GCIC, please?
I do. 1 moment.
This is position 7 and 8.
I have 17 arrest cycles beginning in 1990. Within the last 10 years, you have an FTA from 2015, 2022, 3 from 2023, and 1 from 2024. I have a let's see, possible pending case out of, let's see, Atlanta. It's a disorderly conduct. Arrest date was July 16th of 2023. There's no disposition listed on the GCIC for the case. We have a misdemeanor conviction out of Cobb County for criminal trespass from November 15th of 2023. And another misdemeanor conviction out of DeKalb County for disorderly conduct from July 28th of 2023. She took a notable plea on that case. And there's a misdemeanor theft by taking out of Cobb County as well from October 2022.
All right.
That's it, Your Honor.
Thank you.
Mhm.
I do understand this is more than 5 years in lieu of a domestic violence program. And given that she hasn't been arrested for another DV matter in the last 5 years, I will reduce that to 40 hours of community service. And she will be required to undergo an MH or BHET. Which one would you recommend for her, Miss Atay?
Your Honor, she doesn't have any MH issues, and in the last 10 years, I mean, I see only arrests for disorderly conduct, criminal trespass. She doesn't have any,
That's why she's getting an evaluation. I'm not saying she has one. I'm asking her to be evaluated.
I don't believe that she needs the evaluation.
Then we go back to the FBIT.
I mean, she works at a hospital, so, and
Perfect. Then she'll. You let me know.
I guess a BHET.
All right. And Miss Brown, if you decide to plead guilty to this charge and your bench warrant will be dismissed, you'll be required to report to probation every month. You'll be required to stay away from 1638 Westlake Court and have no contact with Byron Keith. You'll also be required to do 40 hours of voluntary community service and submit to a behavioral health evaluation and accept any treatment or medication that's required by the evaluator. If you decide to accept these terms, I can move forward with this plea. Otherwise, I can reschedule your case for a trial.
Your Honor, I'm sorry. Can I also ask for some of the probation fees to be waived?
I will waive it for up to 3 months.
And go non-reporting once she completes the.
Absolutely not.
Okay.
So, Ms. Brown, would you like to accept these terms or would you like to have a trial?
I accept the terms.
Ms. Atay, do you stipulate to the factual basis, venue, and ID?
Yes, Your Honor.
Ms. Brown, have you consumed any medicine or alcohol recently?
No.
Have you understood? I'm sorry?
No, Your Honor.
You've not consumed any medicine recently?
I don't smoke nor drink.
Have you had to take any medication recently?
Yes, ma'am.
All right. Even after consuming your medicine, are you still able to understand the proceedings so far?
Yes, Your Honor.
Are you satisfied with your legal services?
Yes.
Is anyone inducing you or forcing you to take this plea today?
No.
And if you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get an opportunity to go back to court with your attorney to challenge these charges in a court of law, to confront your accuser, to be able to present any evidence to challenge the charges, to be able to present your arguments and defenses, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to one count of battery, family violence from February 3rd, 2019?
Guilty.
Your sentence is going to be 12 months to serve 144 days. Credit for time served 72 days. You will not have additional jail time. You'll be released if you have no other cases holding you at the jail. You will report to probation Monday. Today is Thursday, so you will report on Monday. I believe that is August 5th. Before 3 p.m. Do you understand?
Yes, Your Honor.
The probation office is located at 132 Mitchell Street in downtown Atlanta.
Oh, yeah, I know this.
Do you know where it is?
Yes, Your Honor. I know where it is.
That's good. Don't forget to report there on Monday before 3 p.m. While you're on probation, you are to have no contact with Byron Keith and to stay away from 1638 West Lake Court in Northwest Atlanta.
West Lake Court.
I will waive your probation fees for the months of August, September, and October. And then beginning November 1st, you must start paying your probation fees. While you're on probation, you will complete 40 hours of voluntary community service with a minimum of 10 hours in the first month and then minimum of 5 hours every month thereafter. Within 30 days of being released, you will submit to a BHET, which is a behavioral health evaluation with any healthcare provider, and you must submit yourself to any counseling or treatment as recommended by the evaluator at your expense. If you do not report to probation every month, or if you violate any of the conditions of your sentence, or if you get arrested again, probation has a right to seek a warrant for your arrest and you to serve out the rest of the sentence in jail. Any questions?
No, ma'am.
Thank you. That concludes. Your bench warrant is now passed.
So she said I can go home with it. So I need to put that back there.
Next, we have position number 17 and 18 in quorum 2.
They'll give it when you get to.
This is State versus Jacory Dudley, accused of willful obstruction of an officer from December 27, 2023. Case number 23 CR 8450F. Mr. Dudley has another case.
That's correct, Your Honor. I didn't have an opportunity to look that up this morning. I did want to know what's going on with that one. I do have the case number.
Okay, that other case is 24 CR 003-810F. And then, of course, position 17, which is the fair evasion and misdemeanor possession of marijuana, 22 CR 274F. So that's 3 cases in all.
Again, it appears that the 810F case is not on calendar. I just need to know if that has been placed on the calendar and if a bond has been set.
All right. I thought this was a global recommendation for all 3 cases, but
well, that's what we were hoping as well. But the 3rd case is not on calendar for some reason.
Your Honor, if you could just give us a moment, we can actually make a recommendation on the 3rd case and present a global recommendation to the court and to the defense.
All right.
All right.
I thought it was a global recommendation for all 3 cases, but I'll hold, not a problem. Thank you.
I do not see the 3rd case on here, so it doesn't look like that was added on, but we will go ahead and because it does say concurrent with, but I'm not seeing the actual recommendation. So we'll pull that and present that.
Okay.
Also, Your Honor, is the recording on? I see that the YouTube is on.
Ms. Lewis?
Let me see what happened.
All right. So Ms. Falk, go ahead and review that. Mr. Dudley, we're going to hold until the state can verify that the global recommendation applies to all 3 cases. And what's the next? And then as soon as there we go. And courtroom 2, do we have another case to address, or shall I go to ACDC?
Yeah, you can do ACDC. I have the last one for she's going to be on probation calendar. Positions 1 and 2.
Okay.
The name is Miss Lundy.
I wasn't.
And my probation officer is going to be. Officer Brooks, good morning. Okay.
Good morning.
Brooks, may I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, I do, Your Honor.
Thank you. This is Ebony, middle initial S, last name Lundy. She's got a probation matter 23 CR 804J, and which she was convicted of a 1 count of battery. And Miss Lundy's probation violation case is 24 PV 1274. Miss Lundy, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Coleman. Would that be you? Mr. Coleman, who represents Miss Lundy in the probation violation case?
That would be Mr. Tay.
All right.
Just 1 second. They're doing the probation case.
Deputy Francois, do you also know where Joshua Smith is? He's got the other probation case.
Is he supposed to be here at ACDC?
I don't know. I just thought maybe you have that information at the tip of your fingertip.
Oh, say the name again? I can look it up for you.
Joshua Lamar Smith.
Joshua Smith is on the floor. He should be appearing on jail court iPhone.
Okay, thank you. Okay. Miss Officer Brooks, what is the recommendation for Miss Lundy?
The recommendation is to continue on probation.
All right. And what was the reason for the violation?
She was court ordered to complete 8 weeks of anger management and to have no contact with her victim. And it was to go non-reporting once she completed her conditions, and she did not complete the classes. And she still has fees of $245 outstanding as well.
When was the conviction date?
February 23rd, 2023 is when she was placed on probation.
Okay, and how many days left on probation?
125 days, Your Honor.
Okay. And I'm sorry, Officer Brooks, I keep asking you 21 questions, but how many classes did she complete?
1 moment, Your Honor. We don't show that she's completed any of the classes, Your Honor.
Okay, thank you. Miss Ate?
Yes, Your Honor. She tells me that she did either 3 or 4 of the anger management classes online. She said she had the app on her phone and did half of the classes.
Have you seen this app or these classes being completed? Have you seen anything?
I don't have access to those things, but she explained to me that she had the app, she would log in, do the classes. But that's just what she told me. I have
Do we
not.
have a time frame?
I don't get a time frame, Your Honor. I have a time frame of the time. Okay, Your Honor, she's been in custody for 79 days. She was arrested for theft by receiving, and those charges were dismissed on June 12th.
Okay.
On June 12th. So she has been in custody since June 12th for this probation violation hold. So that's, I think, 51 days. So I'm just asking that's time served. I mean, or at least to reduce the 125 days of probation.
Was
by
she
that.
arrested on the theft by receiving charge, or was she arrested on the probation violation?
She was arrested by the theft for the theft by receiving, but those charges were dismissed. She said that her boyfriend said she stole the car, but he let her use it, and he then later said that he did let her use it. So the charges were dismissed on June 12th. And it's August 1st now, and so she has been held since June 12th for the probation violation. And
Your Honor, if I may.
Yes.
Yes, the charges that we have for this particular case is battery, Your Honor.
Understood. I just want to be sure, why was she being held? Was it for the probation violation? Did the warrant kick in, or was she
It's the
arrested on a
probation-
new charge?
no, there's no other new charge.
Okay.
It's been 51 days. 79 total days in custody for charges that ended up getting dismissed. She's not in a position right now to pay for probation, to pay for classes. She's been in custody for 79 days.
Okay.
For really just this probation violation.
1 second, Your Honor. I'm trying to see if I can see if it was for our warrant. Give me 1 second.
Okay.
The charge was on May the 15th, 2024 in College Park for theft by receiving stolen property, felony, willful obstruction of law enforcement officer, theft by taking felony, and then the probation violation. So that's what I show in the local search records.
Yes, and all of those were dropped on June 12th. And I don't know why it took so long until August to get her on.
She also has a hold from Cobb County.
Cobb County hold as well, my goodness. So once I continue on probation, she will be transported to Cobb County.
Yes.
Okay. I'm going to continue her on probation. Once she is, she's not getting any credit for the time that she's been at Fulton County Jail. None. I understand the case was disposed of, but I'm glad her boyfriend, stepped up and resolved that matter for her.
But it was disposed of June 12th.
Ms. Atay, I'm not giving her any credit for the time she's been in jail, because she was required to simply do 8 anger management classes from a prior conviction, and she failed to do so for almost over a year and a half. But once she has resolved her Cobb County matter, she has 125 days left on this probation, which will start as soon as she's released from Cobb County. She'll be required to report to probation twice a month. I will waive her probation fees, and she's required to complete her 8 anger management classes. If she has completed 3 classes online and she shows that to her probation officer, and her probation officer is satisfied that that constitutes an anger management class, then a probation officer will definitely give her credit for 3 classes, which means that she has 5 more classes to complete. Otherwise, if her app shows that those are not proper anger management classes, then she would need to complete the 8 anger management classes. Thank you. That completes this case, and as soon as we find Mr. Joshua Smith, we can resume with him. Officer Brooks, did you have any question about this disposition?
No, Your Honor, I understood it perfectly. Thank you.
Can I ask you a question, Your Honor?
Ms. Atay, do you know what she's going to ask?
No.
All right.
I can call ACDC unless it's something about the sentence or the probation.
Okay, I understand that I'm going to be placed back on probation once I'm released for Cobb County, but I wanted to know, like, when will I be released for ACDC?
Cobb County will come pick you up.
When would that be? Would that be?
I have no idea. That would be up to Cobb County. It will probably be within the next few days, hopefully, once they're notified that we've resolved your probation hold.
Okay, thank you, Your Honor.
Mr. Tay, if you want to expedite the matter, you can let Cobb County know that she's ready to be picked up to address the other hold. All right, thank you. Next case, please. Thank you, Francois. I appreciate your time.
Thank you, Judge Law. I'll be back for the competency calendar.
All right, thank you.
All right, thank you.
Courtroom 2, who do we have next?
We can go to position number 25 and 26, Mr. Haynes. Paul. Are you ready?
Yeah, you can.
Amari Haynes. And
Sorry, Your
it's gonna be, is it Mr. Bartel's case or?
Yeah, sorry, Your Honor. Mr. Bartel is currently talking to one of his clients. We can go back to position 17 and 18, Mr. Dudley.
Ms. Falk or Ms. Mokeke, are we ready to proceed with Mr. Dudley?
Yes, Your Honor. I did email
Mr.
the
Coleman?
recommendation to Mr. Coleman, but I can give it just on the Zoom as well. I don't know if he has access to his emails right now.
Mr. Coleman, did you get a chance to review the proposed recommendation from the state?
Yes, that was the 12 months probation, no further contact Tracy Thompson, stay away from 2040 Stanton Road, apartment F12 in East Point, and 40 hours of community service.
Yes, and he would get the credit for time served. He's been in jail for 48 days, so it would be served 98 days. Let me do some math.
He's accepting that. We're ready to go forward. I just had run requests as far as the offer on position 18. But we're ready to go forward on all of the cases.
Mr. Dudley has 3 open cases with us this morning. That's 22 CR 274F, accused of possession of marijuana less than 1 ounce and fare evasion from January 19th, 2022. Position 18 is 23 CR 8450F, 1 count of willful obstruction of an officer from December 27, 2023. Oh, sorry, folks.
That's for the one who's waiting.
What?
Yeah, it's the main ones.
And with regards to 24 CR 3810F, Mr. Dudley is accused of criminal trespass causing damage to property and disorderly conduct from May 29th, 2024.
That's correct.
Mr. Dudley, you've been advised of your right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Coleman. Ms. McKechnie, what is the recommendation for all 3 cases?
The recommendation for position 17, possession of marijuana and fare evasion. For count 1, the possession of marijuana charge will be no prost. Count 2, the fare evasion is time served, and he served 6 days from January 19th to January 20th, 2022, and December 28th through December 31st, 2023. For position 18, willful obstruction of law enforcement officers, the recommendation is 12 months, served 8 days, credit for time served 4 days, and a $300 fine. That is going to run concurrent with 24 CR 003810F. The recommendation for that charge, which is disorderly conduct and criminal trespass, for count 1, it is going to be 12 months, served 96 days, credit for time served 48 days. Balance probated, no further contact with Tracy Thompson, stay away from the incident location, 2040 Stanton Road, apartment F12, East Point, 40 hours community service. For count 2, the criminal trespass, it is going to be 12 months to run concurrent with count 1. And I would just ask the court to sound for the victim, Ms. Tracy Thompson, if she is on.
We had two victims in that case, Thompson and Barber. Was there an exclusion for Barber?
Yeah, the stay away can include Ms. Barber as well, or the no further contact.
Okay.
Ashanti Barber.
Mr. Coleman?
Your Honor, we are in agreement, except for position 18, a $300 fine. Mr. Dudley, works as a tattoo artist. Business has been very slow. I don't know if he's actually going to be able to pay the $300 fine. In light of the fact that he was incarcerated for 4 days on that, as well as the time that he's presently in jail, I'm asking that the fine be suspended.
Ms. McCarthy, I'm so sorry. I can't make up my handwriting because I'm trying to write down the plea for the last case. It was balanced, probated, no contact with the victim, stay away from the Stanton Road and East Point. Was there a FVIP required?
No FVIP required. We did require 40 hours of community service.
Okay, that was what I was missing.
Yes, and in regards to position 18, the willful obstruction, the $300 fine, I believe, is statutory for obstruction. So we would request that it be kept in place.
Okay. Mr. Coleman, I can amend that to an additional 40 hours of community service. He'll be required to report to probation every month, and I'll waive his probation fees for the first 3 months, after which he will need to start paying probation fees from November 1st onwards. Is that something your client would like to consider, or would he like to pay the $300 fine?
Would the probation go non-reporting once he's completed all the conditions?
No.
Okay. 1 second. So. Your Honor, we would ask that it be converted to community service, because it's 10 hours for every $100. We're asking that it be converted to 30 hours rather than 40.
Oh, no, it'll be 40 hours.
Very well, Your Honor.
I'm not doing a conversion. I am amending it to 40 hours.
That's fine, Your Honor.
All right.
We stipulate to a factual basis as well as venue and ID on all cases.
Thank you. Mr. Dudley, have you consumed any medicine or alcohol recently?
No, ma'am.
All right, could you please sit up and put your arms down, sir? I want to make sure I have your full attention. And have you understood the proceedings so far in all your 3 open cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes.
And is anyone forcing you or inducing you to take this plea today?
No, ma'am.
If you decide to plead guilty to these 3 cases, you would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your attorney to challenge the evidence brought against you for all these cases, to be able to present your own arguments and defenses, to confront your accusers, as well as to have the state carry its burden to prove all charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of fare evasion from January 19th, 2022?
Guilty.
Your sentence is 6 days, and that concludes the sentence for that case. How do you plead to willful obstruction of a law enforcement officer from December 27, 2023?
Guilty.
Your sentence is going to be 12 months. To serve 8 days, credit for time served 4 days, balance probated, and you would need to complete 40 hours of community service, which you will be in addition to the sentence that you will serve in the next case that we will address. Community service must be done at any nonprofit agency that is not a church and not a school, with a minimum completion of 5 hours per month. With regards to case 24 CR 003810F from the charges of criminal trespass causing damage to property and disorderly conduct from May 29th, 2024, how do you plead to these 2 charges? Mr. Dudley?
You said
Guilty.
guilty.
I can't hear him. I'm sorry.
Guilty.
With respect to these two cases, your sentence is for the criminal trespass causing damage is going to be 12 months to serve 96 days, credit for time served 48 days, balance probated. If you have no other holds at the Fulton County Jail, you will report to probation on Monday, August 5th, before 3 p.m. While you report to probation, you will have no contact with Tracy Thompson and what was it? Ashley Tom. I'm so sorry. Make sure I want to give them
Ashanti Barber, Your Honor.
No contact with Tracy Thompson and Ashanti Barber. You are to stay 200 yards away from both these individuals, as well as from 2040 Stanton Road and East Point. You are to complete an additional 40 hours of community service at any nonprofit agency that's not a church and not a school. As indicated, you will need to complete a minimum of 10 hours in the first month and then 10 hours every month thereafter. Your probation fees shall be waived for the first 3 months, and you will start paying probation fees from November 1st, 2024 onwards. You will report every month for the remainder of the time until your 40 hours of community service is completed and the probation time is concluded. Any questions, Mr. Coleman?
No questions. I will email the plea form on the last case to Ms. Champion once we're done with court.
All right. Okay, if there are no further questions, this completes the matter with Mr. Dudley.
Next, we could go to position number 38, Mr. Malenkon.
I'll just explain what's.
Okay.
This is State versus Rontrell Malenkon. Mr. Malenkon has 23 CR 72398, in which he's accused of loitering and prowling from November 18th, 2023. And he's got a bench warrant from May 21st, 2024, 24 FTA 983. Mr. Malenkon, you've been advised of your right to remain silent, and your attorney is Mr. Bartell.
Well, Your Honor, I just wanted to clarify. I did put it down as a pro se plea. The discovery I have is pretty minimal. It's just a very brief police report. And I kind of had to dig in Odyssey to find that. And based on what's in the police report, I'm not satisfied that the state could prove this beyond a reasonable doubt, or that there was probable cause to charge of loitering. The loitering statute is pretty specific. So, you know, I'm not comfortable putting my name on the plea, but he does know what his options are. He understands that the offer is time served, and he wants to go ahead with that plea.
Is the public defense withdrawing from this case?
Well, if he wants to go ahead with the plea, we would be, Your Honor.
All right. Mr. Malenkon, it appears that your appointed counsel does not recommend that you enter a guilty plea, but you have the absolute right to decide how you would like to move forward, even after consulting with the public defense attorney. However, the attorney will withdraw from the case if you decide to move forward with a guilty plea in this case. And if you decide to do so, then you would be representing yourself. You are responsible for understanding how to proceed with this matter and its impact upon any other open cases you may have and you're responsible for any ramifications or consequences that you make as a result of this decision. Would you still like to move forward representing yourself, or would you like to be represented by the public defender's office?
I would like to be represented by the public defender's office.
Well, if you want to be represented by the public defender's office, they don't want to represent you if you move forward with the plea. So you have to make a decision.
I'm sorry, excuse me. Can you explain to me the charge that I'm pleading to again?
You're being charged with a misdemeanor offense of loitering or prowling, in which the prosecution has accused you of the following charge, in that You are accused with the misdemeanor offense of loitering and prowling on that November 18th, 2023. You did appear at a place, at a time, or in a manner not usual for law-abiding individuals under circumstances that warrant a justifiable or reasonable alarm or immediate concern for the safety of persons or property in violation of Georgia law 16-11-36. You were provided with a signature bond on November 21st, 2023, when you were arrested. And that signature bond was through the jail for $1,500, in which you were required to stay away from all Chick-fil-A restaurants in Fulton County. Apparently, you did not appear for court on May 21st, 2024, and a bench warrant was issued for your arrest because you did not come back to court. So today, you have a right to either plead guilty, but you would have to do it in a self-represented capacity because the public defender's office does not want to represent you for that purpose. Or you can accept the representation and listen to your attorney's recommendation.
I would listen to my attorney recommendation.
All right.
I know.
Well, he is declining to enter a plea, Your Honor, so we would ask to be heard on bond in that regard. We would be asking for a signature bond if the state is not inclined to null process this case. You know, he had indicated that it was going to be a plea, so I'm not sure the exact reason that he wasn't present for court, but he was in the Chick-fil-A apparently during normal business hours, which is not a time or place that's unusual for law-abiding citizens. The report said that he allegedly ate someone else's food, but he indicated that that was a mistake. He thought it was his order, and he came back later to use the restroom. And the officer claimed that it was making other customers uncomfortable, especially with small children around, but you know, there's nothing to go on in that. So based on this, I just don't see how the state can prove this charge beyond a reasonable doubt. So he's already been in jail 17 days. It looks like he's been in jail 14 days on the latest booking and then 3 days on the original charge. And I would submit that that's enough of a punishment for whatever it is he did or didn't do. So based on all that, you know, again, if the state is wanting to move forward, we would just ask for a signature bond.
And you do understand the 17 days in jail was for failure to appear in court. I mean, I'm not sure how the state was punishing him on that. So I'll just put that out there, but I just want to make sure that's how I think. All right. First of all, before Ms. Falk addresses this case, Mr. Bartel, do you file a waiver of arraignment, or would you like me to arraign this case?
We can file a waiver, Judge.
All right. This is going to be a waiver of arraignment, and this case is going to be further notice for trial. Ms. Falk, we've got a bench warrant matter in which she's got $1,000 surety bond. What is the state's response? I'm sorry, Ms. Falk.
Your Honor, this is not the first time the defendant has failed to appear for court. This is actually his second time failing with a failure to appear in the last 5 years. He has a previous failure to appear on December 29th of 2021. That was for a felony obstruction of law enforcement officer and simple battery against a law enforcement officer under 21 SC 177547. The defendant also has it was later convicted for that on February 16th of 2022, specifically the simple battery against police officers. Previous to that, the defendant has a history including disorderly conduct in 2020, criminal damage arrest in 2020. We also have a theft by shoplifting in July of 2023. That was July 9th, and then a different theft by shoplifting July 25th of 2023, and then a theft by shoplifting in November 12th of 2023, and a disorderly conduct in November 18th of 2023, a disorderly conduct in November 20th of 2023, and then this failure to appear. Your Honor, I have yet to hear any compelling reason or any reason at all, in fact, why this defendant failed to appear for court when he was designated to appear for court. And for that reason, we would ask the bond remain as set.
All right. Mr. Bartel, what's your client's current address?
He indicates that he is experiencing homelessness now, Your Honor. And, you know, I mean, the FTA, the charge is there, it is what it is. But as I said, this is one of the sketchiest cases I've seen in a long time. And on such a minimal charge, you know, he's been in jail for 17 days as a result of this arrest. And I would submit that, you know, whatever he did or didn't do, the state has already gotten their pound of flesh out of him. And I would submit he's already been punished enough.
There you go, Ms. Falk. Shakespeare being quoted at this time. Okay. Mr. Malencon's bond on the bench warrants amended to a $2,000 signature bond through the jail. And Mr. Malencon, your case is still open and active, and you need to come back to court for your trial. Your attorney is the Public Defender's Office. If you don't come back to court for trial, we get to arrest you again and keep you in jail until we go to trial. Do you understand?
I understand.
You are required to stay away from all Chick-fil-A restaurants. You cannot go to the sidewalk. You cannot go to the car park. You cannot go inside the restaurant. You cannot order any food at Chick-fil-A on your own. Do you understand? According to my daughter, that is already a huge punishment for any Southerner with any Southern red blood in them. So no Chick-fil-A until you go to trial. Thank you.
Your Honor, I need to point out that under SB 63, which passed July 1st of 2024, because this defendant has had a failure to appear in the last 5 years, he's actually not eligible for a signature bond through the jail. At the very least, he's only eligible for a signature bond through pretrial services.
I understand, but I'm exercising my discretion right now and doing a signature bond through the jail. If he doesn't show back up in court, Mr. Bartel, I'm sure you'll be able to tell him I told you so.
I'm sure that the court will in that event, Your Honor.
Not me, you do that. Okay,
I will.
thank you.
All right, thank you.
Next case, please.
Position number 25 and 26, Mr. Haynes, you can go ahead and have a seat in the back.
I'm sorry, Debbie, I didn't catch the case numbers.
25 and 26.
Thank you. This is State versus Shamari Haynes. Mr. Haynes is accused of battery, family violence from 21 CR 2279G and 21 CR 1913Y. Excuse me, 24 FTA 000981. That would be the bench warrant. Mr. Haynes, you've been advised to be right to remain silent, and your attorney is Mr. Bartel. And how are we proceeding, Mr. Bartel, for this case?
He has filled out the plea paperwork, Your Honor. It is going to be a non-negotiated plea. We are in concurrence with the recommendation, except for the additional jail time.
So it's now a negotiated plea?
Oh, a non-negotiated plea.
Oh, okay.
It's just the jail time is the issue, Your Honor.
Okay. Mr. Haynes, we're going to begin with a non-negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Thank you. Ms. Mokeke, what's the state's recommendation?
The state's recommendation is 120 days, credit for time served 40 days, balance probated, no further contact with Shawan Davenport, stay away from the incident location 4427 South Commerce Drive in East Point, an FVIP, 40 hours of community service and no firearms. That recommendation is based on the allegations in this case, which are very disturbing. Officers arrived at the incident location and noticed that the hotel room had the dresser flipped upside down, clothes and food and all sorts of debris on the ground. They saw the victim, Ms. Davenport, on the bed, shaking and crying. She had 3 lumps on her face, 2 above her eye, 1 on her cheek, as well as a laceration on her elbow and bruises on her left arm. She stated the defendant had been beating her all day. He punched her, kicked various parts of her body, including her head, stomach, back, chest, and kidney area. The victim managed to get out of the room at one point and asked the clerk to call the police. The defendant made her come back into the room and started beating her again, and she stated that she had been trying to get away all day. When officers questioned the defendant, he stated he didn't do anything and he did not know how she got those injuries. Officers did also notice blood on the defendant's body that did not appear to be him. I'm assuming that is the blood of the victim, Ms. Davenport. The defendant has 21 arrest cycles, including a 2021 battery conviction. He does have a 2012 battery family violence that was dismissed. So based on, what happened in this case, we believe that 120 days is very appropriate given what was done to this victim. I would ask the court to sound for Ms. Davenport if she is on the Zoom.
And I'm sorry, what was the conviction date that you mentioned?
It was 2021. I can get the exact date for you if you give me just a moment. I just have the year.
And that was for what?
It was a battery.
Okay, but it was not DV at that time?
No, it was not a family violence. I just have it as a battery.
All right. Okay, while we're waiting for that information, Mr. Bartel?
Yes, thank you, Your Honor. I have met with Mr. Haynes and let him know of his options and discussed this case with him. He is 29 years old. He has been in Georgia ever since 2 years. He was 2 years old, I'm told. So I'm told he's been in Georgia 27 years and that his family, including his mother, brother, and aunts and uncles all live in the metro Atlanta area. So he does have ties to the community. I am advised that since this date, he has not had any contact with the alleged victim. He does dispute some of the allegations, but we would stipulate that there's a factual basis for the purposes of the plea. He has been looking for a job. He's been working on getting an official ID and a birth certificate, which he needs to get a job, and he was working on that up till the point where he was arrested. And this is over 3 years old, Your Honor. Again, he indicates, or I'm told that there's been no contact since then. He also has a GED that he went to school and got when in the last few years. So he also wants the court to know he's concerned about the FTA. I did look it up, and Mr. Haynes indicated that the notice, the address to which the notice was sent was misspelled, and that's why it was not delivered. And he wanted the court to know that he never got the notice, and that's why there was the failure to appear. But be that as it may, he served 14 days so far. It looks like he served 26 days total. So that would be 40 days, and 2-for-1 credit. We're asking for 80 days to serve rather than the 120 days. And we would be in concurrence with all the other conditions of the state's offer.
Excuse me. If you just give me a moment, I want to check on another case regarding Mr. Haynes.
And I do have that battery conviction date whenever you're ready for it.
What is it?
It is September 14th, 2021, and that was in Spalding County State Court. The date of the incident I have is September 15th, 2021.
Okay. Just give me a moment. I'm looking up another case involving Mr. Haynes, 23 CP 121459. And I don't know if I got that case number right. Mr. Ms. Lois, I'm not sure, but I think there may be an open Superior Court matter. I don't know if I got the case right.
What position does this on, Judge?
This is Shamari Haynes. I just want to be sure there aren't any holes from Superior Court. Twenty-three CP 219-459. 219-459. Just got the numbers transposed.
Your Honor, it looks like on that case, he was given a $1,000 split UJR jail county with a jail county paid ankle monitor. And was told to stay away from 3200 Lakeview Place.
So it's an open case. Okay, thank you.
That is correct.
Mr. Coleman, I'm going to go with the state's recommendation. Would your client still like to move forward with this? Oh, sorry, Mr. Bartel, I do beg your pardon.
Problem, Judge.
I'm going to go with the state's recommendation. Would your client still like to move forward, or shall I arraign the case for trial?
Okay, I'll talk with him.
Please mute your screen, sir. Got it muted. Thank you.
Yes, Your Honor. I've relayed to him the court's position, and he'll said he wants to go forward with the plea.
All right. Mr. Bartel, do you stipulate to the factual basis, venue, and ID?
For the purposes of a plea, we do, Your Honor.
All right. This is Mr. Haynes. I don't know if I placed you under oath, but let's go ahead and do it again. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
Mr. Haynes, have you consumed any medicine or alcohol recently? Speak up, please.
No, ma'am.
And have you understood what's going on in this particular case?
Yes, ma'am.
And you are aware that you have an open case in the Superior Court of Fulton County?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
And has anyone forced you or induced you to take this plea today?
No, ma'am.
If you decide to plead guilty to this charge, you would have to give up your constitutional right to a trial in front of a judge or jury for this particular case. You will not have the opportunity to go back to court with your attorney to confront your accuser, challenge the evidence brought against you, to be able to present any defenses, arguments, or mitigating factors, and to have the state carry its burden to prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
Repeat.
Yes, ma'am. Yes, ma'am.
Yeah, he's indicating yes, Your Honor.
All right, I'm so sorry. He needs to speak up because this is being recorded and
Yes,
it
ma'am.
needs to be heard. All right.
He's a soft-spoken guy. You got to speak up.
Now's the time to speak up and be clear. Mr. Haynes, how do you plead to one count of battery family violence from May 8th, 2021?
Guilty.
Your sentence is 12 months to serve 120 days. Credit for time served, 40 days. You will have additional jail time to serve at the Fulton County Jail. If you have completed the jail time and you're released from any other holds, then you will immediately report to probation at 132 Mitchell Street, which is which will be open on any Monday, Tuesday, or Thursday. You must report before 3 p.m. While you're on probation, you will complete a domestic violence intervention program, which you must enroll within 45 days of being released. You will also complete 40 hours of voluntary community service with any nonprofit agency, and that cannot be a church and a school. You must complete a minimum of 5 hours every month, and then 5 hours every month thereafter, a minimum of 5 hours every month thereafter, until the 40 hours are completed. You are not allowed to own or possess any firearms. As this is a conviction of family violence, you are not allowed by law to own or possess any firearms from this moment onwards. You are to have no contact with Siobhan Davenport. You are to stay 200 yards away from Ms. Davenport and not communicate with her in any way, form, or manner, including a third party and on social media, and to stay away from 4427 South Commerce Drive in East Point, Georgia. Thank you.
Thank you, Your Honor. Thanks.
His French loan will be Norcross.
Position 32 is downtown. So I guess
All right, next
Yeah.
year, position is 34, 35.
Oh, okay.
Jail court iPhone, could you repeat what you just said? I couldn't make out.
I'm sorry, we have position 34 and 35.
Okay, got it. Thank you.
Mark.
This is State versus Nishon Tyrone Martin. In position 35, Mr. Martin's case is 24 CR 4918A, in which he's been accused of 2 counts of battery family violence from June 25th, 2024. His second matter is on position 34, and that is 24 CR 4907A, in which he's accused of 2 counts of battery family violence from July 18, 2024. Mr. Martin, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Paul Bartel. Mr. Bartel, with regards to your client in at the jail court iPhone, how are you proceeding?
Yes, Your Honor. This is a non-negotiated plea. We are, as with the previous situation, we are in concurrence with all the conditions except for the amount of jail time.
Mr. Martin, are you able to hear us? I just want to be sure.
Yes, ma'am.
Please raise your right hand. For purposes of the plea, do you swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
Thank you. Ms. Falk, what is the
Yes, Your
state's recommendation for Mr. Martin in both his cases regarding the 4 charges?
Yes, Your Honor. So this is a global recommendation as to both cases. The state's recommendation on position 34 is 12 months served, 90 days, credit for time served 15 days. That's going to be from July 18th of 2024 until today. No further contact with Alicia Tolbert, no firearms, FVIP, 40 hours of community service. Position 35, count 2 of the family violence battery would merge with count 1. Position number 35, the family violence battery offense would be 12 months served 90 days, credit for time served 15 days, no further contact with Alicia Tolbert, no firearms, FVIP, 40 hours of community service. That is to run concurrent with the previous case, and then count 2, 12 months concurrent with count 1. We are, just to kind of give Your Honor an overview of both cases, on July 18th, 2024 at 240 Grant Street, Southeast, apartment 3112. The defendant officers were called out, spoke with Ms. Tolbert. She advised that she had tried to come to the home to retrieve her belongings, and the defendant attacked her by slamming her hand on the door. She's slamming her hand in the door. She stated she had bruises, scratching, and bleeding. They met with the Ms. Tolbert. She stated that he slammed the door on her left hand, dragged her out, which did result in bruises and scratches on both of her legs. At that point, I believe the defendant was not at the residence and a warrant was issued for him. The other case happened June 25th of 2024. In that case, officers responded to 240 Grant Street Southeast in Atlanta, spoke to Miss Alicia Tolbert, who stated she was attacked by the defendant. She stated that she was talking on the phone. The defendant did not want her to. He came out of the shower, smacked the cell phone out of her hand, and began to squeeze her neck while tossing her around. She did have cuts and bruises on her arms and neck, and she stated that they had been living together, had known each other for 5 months, and that he is unemployed but does security and host parties on the side. Again, the defendant was not present at the time, so warrants were issued for him. Additionally, the defendant's history, the defendant has an open battery and family violence battery under 24C 04523 in DeKalb County. Those charges have been accused and are still pending. That is of great concern for the state, being that there is now 3 family violence charges, which are all open and active against the same defendant. So although he does not have any previous history previous to now, there is a trouble pattern emerging here, which is the reason why the state did request 90 days in jail as a resolution to both. He will then need to address his DeKalb County charge at a later time. That's all for the state. We would like to sound from Miss Alicia Tolbert, please.
Ms. Tolbert, if you are present, this is the time to unmute and start your video. Mr. Bartel?
Yes, thank you, Your Honor. I have met and spoken with Mr. Martin. As I indicated, we are in concurrent with all the recommendations of the state except for the amount of jail time. He has been in, as the state indicated, a total of 15 days. So we would ask the court to consider a sentence of 30 days to serve with the remainder on probation and all of the other conditions that were discussed. It does appear that he has no previous convictions. If there's the open case there, I can't speak to that because I don't know the details of that, but he is 20 years old. He indicates that he has been going to school to get his GED through Georgia Tech, and he indicates that that is starting back at the end of next week. So that is one reason why he is anxious to be able to get out of jail and be on probation and continue moving forward with his life. He also has 2 children. He's involved with their care, and I've indicated that their mother works and he helps look after the children. So he does want to get out of jail to continue helping with that. He did indicate that he works security with the HART security agency, and he also indicated to me he's got a job lined up at the McDonald's on Old National Highway. So given all of that, he is asking the court to consider giving him the time served, the 30 days to serve with probation and all of the other conditions. And that's all I have now, Your Honor.
In reviewing both these matters, including the fact that he's got a DeKalb County open case and as well as the underlying allegations, Mr. Martin, the court is willing to reduce the jail time to 40 days to serve 15 days, which means that you have an additional 5 or 10 days. I'm not sure. You'll have an additional 5 days. Upon your release, you would need to be equipped with an ankle monitor, and you would need to pay the monitoring fees, which can go up to $300 a month. And you'll be required to pay those fees every month. Failure to pay those fees can result in your probation being revoked and you're back in jail to serve out the rest of the time. And these ankle monitoring will be required for a minimum of 6 months. Mr. Bartel, is this something that your client is, you want to talk to him, or otherwise we can go with the state's recommendation?
Mr. Martin, if you want to accept that, we can go forward. Or if you want to talk to me, I can answer some questions in private. But
you come back. Or you're going to a breakout, like a little private. Yeah, that's it. So, we said, yeah, if you want to talk to him, discuss, and then I come back.
Yes, I will talk. I will want to talk to my attorney, then come back.
All right. Please hold. Mr. Bartel, if you want to get on a separate device, I can put you in a breakout with jail court iPhone.
Okay,
Yes,
very well.
Ms. Lewis, once Mr. Bartel joins the Zoom on a separate device, I think he already is. Could we put him in a
Yeah,
breakout,
I
please?
see him. I got it.
All right, thank you. Next case in courtroom 2, please.
Your Honor, I have a question for two defendants. Do we know who's representing position 3, Bailey David, and position 50, Barry Williams?
You are asking about David Bailey. Who represents David Bailey? All right, hang on. Amar Bolden, go put on a shirt and switch off your video. I don't know where folks get the idea this is how you appear in court. All right. And Mr. Coleman, position number 3, David Bailey.
No, we don't represent. The notes that I have on the calendar is that we should conflict out of this because we represent a co-defendant.
Okay, so this will have to be conflict counsel.
Correct.
And if we don't have one right now, one will have to be appointed and the case reset. Let me check and see.
Oh, I guess we need to know from Ms. Falk if this is going to be transferred to the DA's office.
Ms. Falk?
I'm sorry, I feel like I heard position 50.
No, 3.
Also
Bailey.
position 50, but position 3 as well.
Okay, so position 3, Your Honor?
Yes.
Yeah, the calendar indicates it's a potential transfer to the DA's office, so we need to know if that's going to happen.
Right, I just need to double check. I know I sent them an email to request a transfer. Let's see, they have not responded to the email yet. However, because this is a recidivist offense, he had 1, 2, 3, 4, 5 previous convictions. Recidivist only requires 2. I believe that they will accept the case, Your Honor, if we could just continue it for 1 week to allow us to get that paperwork. They have been actually pretty responsive lately.
This case is reset to August 8th. Ms. Champion, please contact Mr. Dennis Murphy.
And that
Also, while we're on the subject.
Please hold, Mr. Coleman, I'm so sorry. Ms. Champion, please contact Mr. Dennis Murphy and see if he'll take this case as a conflict matter.
Yes, ma'am.
All right, so reset to August 8th. I'm sorry, Mr. Coleman, can we just address position 50 before we move on?
Sure. Position 50 again on the calendar that I have, it indicates that there is actually a private attorney. Yeah, to 8-8.
50?
And
this is Barry Williams, right?
The private attorney is a G. Ferrick.
G. Ferrick, I've got that listed as an officer.
Oh, I'm sorry. Yeah, maybe that's the officer. But yeah.
Yes, he doesn't have counsel.
Yeah,
I'm not seeing counsel listed either in his case manager.
Right. Mr. Coleman had, he was actually represented. He was before Judge Mather, failed to appear. I don't think he's spoken to PDs to see if he qualifies.
No, and again, the information I had was that there was a private attorney on this case.
There is not a private attorney.
Deputy, is Barry Williams in the courtroom today?
Yes, Your Honor.
All right, Mr. Coleman, if you would please confer with him to see if he qualifies for the PDs. He has got a traffic matter in which he failed to appear before Judge Mather on February 28th, 2020. He's in jail on a bench warrant with regards to this traffic matter.
Okay, is this all that he has?
For as far as I can tell, yes, sir.
Okay. All right, I'll speak to him. Also, while we were on the subject of potential transfers to the DA's office, position 5, do we know if that's going to be transferred?
Calvin Banks?
Calvin Banks was similarly situated. We did send a email to the DA's office. We are waiting to hear back. But again, Mr. Banks, I believe, had 4 previous convictions for theft by shoplifting. 5, and the requirement is 3. And so we are just waiting to hear back from them in regards to that case as well.
Yeah,
And if we could reset for 1 week.
Do we know about number 32, Mr. Malone, same situation?
All right, just 1 second. Calvin Banks, any objection to the reset, Mr. Coleman?
No, that's fine. I was already requesting a reset. I just want to know if it had actually been accepted by the DA's office.
All right, thank you. Now, Mr. Bartel, I'm sorry, what case did you want to position 32?
Yes, Your Honor. That's Jason Malone. It was a possible transfer to DA. I'm told that he's gone downtown. Does that mean that it's gone to the DA's office?
Let me just check.
I know there is a pending felony for him as well.
Jason Malone was accepted. I transmitted the order on Monday at 3:11 p.m. It was signed by the DA and has been accepted as a felony.
Okay, so we don't need to do anything else with that.
I do not believe so. Let me just check and see if there is a PI number that I can give you and the court on that.
Okay, thank you.
All right, maybe move on to our next case. Mr. Bartel, have you spoken to your client?
I have, Your Honor. I spoke with him and he said he is wanting to accept the court sentence and move forward with the plea.
And Your Honor, if I may just give the, on Jason Malone, if I can just give the court and the defense the PI number really quickly.
You may.
The PI number is 24 PI 1004918.
I'm sorry, could you repeat that, Ms. Falk?
24 PI 004918.
918. Okay, thank you.
Thank you.
All right, returning back to Mr. Nishon Tyrone Martin. Ms. Falk, anything else to add based on the court's amendment to the jail time and the imposition of the ankle monitoring for a minimum of 6 months?
Nothing. The state asked the defense stipulate to venue factual basis and identification for the purposes of the plea, but nothing else.
We would so stipulate.
Mr. Martin, jail court iPhone, please unmute. Right, Mr. Martin, with respect to your 2 cases, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood what is the recommendation and the potential disposition in both your cases?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anybody forcing you, inducing you to take this plea offer today?
No, ma'am.
If you decide to move forward with this plea, this will be 3 separate convictions for battery, family violence on your record.
Just to clarify, it will be 2, correct?
Well, it'll be 1 from the position 34, and it will be 2 from position 35.
Okay, I think both cases were going to merge. My understanding was that in case number 35, the 2 would merge too. It's the same unit of prosecution.
I have on Ms. Falk, why don't you? Because I have on position 34, count 2 will merge. And on position 35, count 2 is 12 months concurrent with count 1. I mean,
Let me just double check that for a moment. Your Honor, the state will agree to merge count 2 into count 1 on position 35.
okay, so let me amend that. Okay. So after that amendment, Mr. Martin, if you decide to move forward with pleading guilty to both cases, this will be 2 separate battery family violence convictions on your record. Are you still willing to move forward?
Yes, ma'am.
You understand that if you are ever arrested again for a battery family violence, that will automatically be a felony charge.
Yes, ma'am.
All right. And I've already asked you if you're satisfied with your legal services. Are you entering this plea freely, willingly, and knowingly?
Yes, ma'am.
You would have to give up your constitutional right to a trial in front of a judge or a jury. You will not get the chance to confront your accusers, to be able to challenge the evidence presented against you, to present any defenses, arguments, and mitigating factors, and to have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to 1 count of battery family violence from July 18th, 2024?
Guilty.
How do you plead to 1 count of battery family violence from June 25th, 2024?
Guilty.
Your sentence is 12 months to serve 40 days, credit for time served 15 days. No further contact with Alicia Tolbert. You are to stay 200 yards away from her, not communicate with her in any way, form, or manner. And you are not allowed to possess any firearms. You're not allowed to have any firearms in your home, on your person, or anywhere near you.
Yes, ma'am.
Once you are, once you're released, you have to report to probation. If you have no other holds, you have to report to probation on Monday, before 3 p.m. at 132 Mitchell Street. Before you are released from the Fulton County Jail, you are to be equipped with an ankle monitor for a minimum period of 6 months. The ankle monitoring fees are to be paid by you out of your own pocket. If you miss 2 consecutive payments, in other words, if you miss 2 payments month to month, back to back, you will be required, probation will be required to issue a revocation warrant, and you'll be arrested and brought back to jail to complete the rest of your probation term in jail.
Yes, ma'am.
While you're on probation, you are to enroll in a domestic violence intervention program within 30 days of being released, and to complete 24 weeks of those classes with no interruptions. You're also to complete 40 hours of community service with any nonprofit agency that's not a church or a school, and you are to complete a minimum of 5 hours per month. Oh, I'm
Yes,
so
ma'am.
sorry. You won't be reporting on Monday. You will be reporting as soon as you're released after completing 5 additional days in jail, which means that you will report on Thursday, and that would be August 8th, before 3 p.m.
Yes, ma'am.
And Your Honor, just to clarify, I understand the FVIP is part of both sentences. He would not have to complete that twice, right? That would just.
Correct. It'll be 1 FVIP class, 1 FVIP program. That's
Right.
24 weeks of classes for
Right.
both cases. And the 40 hours community service, 1 time for both cases.
Both cases. All right, thank you, Judge.
And the ankle monitoring, 6 months for both cases. Okay, that concludes the case. Thank you.
Thank you, Judge. 34, 35.
Next, we can go to position number 21 and 22, Mr. Fowler.
You can sit here, sir. Thank you, sir.
Okay. This is Tom, middle initial E Fowler, case 22 CR 6167C, and a bench warrant 24 FTA 977. In the original case, he was accused of improper lane change, driving while license suspended or revoked, and misdemeanor possession of marijuana, less than 1 ounce, from May 21st, 2021. A bench warrant was issued against Mr. Fowler for failure to appear in court on December 15th, 2022. Mr. Fowler, you've been advised of your right to remain silent, and your attorney is Mr. Bartel. Mr. Bartel, is this going to be a non-negotiated plea?
It is, Your Honor. It's just the fine amount on the suspended license that we would ask to be heard on.
All right. Mr. Fowler,
No.
yes. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, ma'am.
All right, thank you. Ms. Mokeke, what's the recommendation for both these cases?
The recommendation for count one, the improper lane change, is 12 months concurrent with count two, $265 fine. The recommendation for count two, driving with a suspended license or license revoked, is 12 months served 30 days, credit for time served 15 days, balance probated, $1,000 fine. For count three, possession of marijuana, the state would move to null pros that. The fine amount is based off of the defendant's previous convictions for driving with a license suspended. There's one from 2015 and also one from 2022. I do see that he had an arrest for the same thing in 2013 where the time expired, and again in 2010 where the time had expired. In this instance, the officers were conducting a traffic stop because the defendant made an illegal turn on a double yellow line. The officers observed the defendant throw marijuana out of his car, and when they ran his information, it did come back that his license was suspended. Of course, upon a guilty plea, we would null pros the FTA.
All right, and Mr. Barton?
Yes, thank you, Your Honor. I did speak with Mr. Fowler about his case. He indicated that he has been working at JPL Auto Lot. It's a car business in Jonesboro. However, that's not full time. And he indicated that he not too long ago lost his apartment. So he is having some financial difficulty regarding the fines. He's willing to accept the $250 fine on the improper lane change, $265. That's a very precise amount, but it's an amount that he is willing to agree to. On the suspended license, because of his financial situation, we would ask the court to consider a $500 fine and give him the option of being able to do community service 50 hours in lieu of that. I know that would be up to probation, but it would depend on his ability to serve. And we also would ask if the court would accept a NOLO plea on the driving with a suspended license charge. I have indicated to Mr. Fowler that without really being able to have a complete driving history, I can't say for sure if even a NOLO plea would or would not result in an additional license suspension period. So he understands that. But we would still ask to be able to enter a NOLO plea on that charge.
Ms. Tyson, would you happen to have Mr. Fowler's DDS driving history by any chance?
No, Your Honor, I don't have it. I just have his criminal GCIC.
And I'm sorry, Mr. Bartel, Mr.
My understanding is that a NOLO plea more than once every 5 years to a license category charge would count as a conviction. And I've advised him of that.
Given his 2 prior convictions for driving while license suspended, given his 4 prior arrests for driving while license suspended, and with the court's great concern that he works for an auto lot, I'm not going to accept a NOLO contendere. But I'm willing.
He does maintenance and like odd jobs around the property.
Understood, but it's still with vehicles. Furthermore, the court is willing to amend the $1,000 fine to a $500 fine plus 50 hours of community service and a mandatory license suspension for the next 12 months. He won't be eligible for reinstatement for the next 12 months.
If I could have a moment to talk with him about that, Judge.
Yes. Deputy in courtroom 2, do you have another case I can address in the meantime, or jail court iPhone? Is that Mr. Coleman's client?
Yes, we can do Barry Williams position 50.
All right, thank you, Mr. Coleman.
You gotta sit down. You can't stand up.
All right, Mr. Coleman, this is Barry Eugene Williams, case number 19 CR 1621G, who was arrested for suspended or revoked license or defective or no taillights. He was arrested on a bench warrant, apparently. Mr. Williams, you've been advised of your right to remain silent, and I guess after conferring with Mr. Coleman, he qualifies for the Public Defender's Office?
He does, Your Honor.
All right, sir. And how are we proceeding?
This is gonna be a non-negotiated plea.
All right. Mr. Williams, for purposes of the plea, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
I do.
Thank you. Ms. Falk?
Your Honor, I would just inquire what portion of this plea is non-negotiated, being count 2 is time served and count 1 is a $500 statutory fine for suspended license.
I'm objecting to the fine. Speaking to Mr. Williams, he only earns about $500 a month, which is why he qualifies for the public defender. And in light of the fact that he has been in custody for the last 16 days, I'm requesting that the fine be suspended. Additionally, I'm requesting that this be entered as a nolo plea, as Mr. Williams states to me that he has his license back now. This is a 2017 case, so it is a 7-year-old case.
His license is going to be suspended again if he pleads to this charge.
Well, we're asking that it be entered as a nolo plea. I think that it would save his license.
Also, it will.
I don't believe so.
Yeah, if this is his first conviction for this type of offense in the last 5 years, it should not suspend it.
I'm not going to accept that, sir.
Okay, may I have a moment to speak to Mr. Williams then?
Yes, sir. Mr. Bartel, are we ready to proceed?
We are, Your Honor. Okay, I just wanted to clarify, are you saying that you want to accept it as a nolo plea?
I'm not accepting it as a nolo plea. It's a driving while license suspended. His 16 days in jail was for his failure to appear.
Okay, and as far as the fine being suspended?
I haven't heard both arguments yet, so I'm reserve ruling on that.
Okay, so
okay, let me get back to Mr. Bartel's client. And what position number was that again? I'm sorry, I lost my place.
21, Your Honor, and
21. Okay, got it.
The FTA, I believe. And
there we go.
Indicated he wants to go forward with the plea if that's going to be the court sentence.
Mr. Fowler, I'm sorry, Mr. Bartel, you stipulate to the factual basis, venue, and ID?
We do for the purposes of entering a plea.
Yes, sir. Mr. Fowler, have you consumed any medicine or alcohol recently?
No, ma'am.
And have you understood the proceedings in your case?
Yes, ma'am.
Are you satisfied with your legal services?
Yes, ma'am.
And is anyone forcing you to enter this plea today?
No, ma'am.
If you decide to plead guilty to improper lane change and driving while license suspended or revoked, you would have to give up your constitutional right to challenge these charges in a court of law. You will not have the opportunity to go back to court to confront your accusers, challenge the evidence brought against you, and have the state carry its burden to prove the original charges against you beyond reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to improper lane change?
Guilty.
How do you plead to driving while license suspended or revoked?
Guilty.
I'll accept your guilty plea to these charges. The misdemeanor possession of marijuana charge is dismissed. The bench warrant is also dismissed or null prost. On the improper lane change, the sentence is 12 months probation, concurrent with count 2, and you have to pay a $265 fine. On the driving while license suspended, it's 12 months probation to serve 30 days, credit for time served 15 days. You'll be released within 24 hours and you must report to probation on Monday, August 5th before 3 p.m. While you're on probation, you must pay a $500 fine on the driving while license suspended and of course, the $265 fine on the improper lane change. You will also be required to do 50 hours of voluntary community service, and that community service must be done at any nonprofit agency or that is not a church and not a school. In addition to that, you'll be required to do a defensive driving program. And you can do that defensive driving program anytime during the next 12 months. And in addition to that, there's a mandatory license suspension for 12 months. You'll be eligible for a license reinstatement after the 12 months have lapsed. And that will be 12 months less 15 days. Anything else, Mr. Bartel? Have I missed something?
Nothing else, Your Honor. Thank you.
All right, thank you.
Thank you. Thank you, sir. Appreciate it. You're welcome.
Mr.
I think Joe Court has one.
All right. Next, we have position number 6.
Okay, Mr. Coleman, I'll be back with your client, Mr. Williams.
Yeah, unless they want to do something else right now.
That's Mr. Williams seated next to you, right?
Yes, it is. We are ready with Mr. Williams.
All right, jail code iPhone, I'll be right with you. What position number was that?
Mr. Williams.
iPhones or?
Yeah, what position number?
Position 6, I think.
Okay,
Yes,
I'll be right with you. Just give me a moment.
Okay, no problem.
Mr. Coleman, is your client moving forward with a guilty plea or a not guilty plea?
Guilty plea, Your Honor.
All right. With regards to Mr. Williams, we've already gone over the issue of whether he's entering guilty plea. Ms. Falk, it's a 12 months probation to pay a $500 fine and probation to terminate upon payment of fine. And the defective or no taillights is time served, 32 days to serve 16 days. Would that be correct?
That is correct, Your Honor.
All right. And Mr. Coleman, your client, you stipulate to the factual basis, venue, and ID?
We will so stipulate.
All right. Mr. Williams, have you consumed any medicine or alcohol?
No, ma'am.
And have you understood what's going on in your case?
Yes, ma'am.
And are you satisfied with your legal services?
I am.
If you decide to plead guilty to these charges, you would have to give up your constitutional right to a trial, to confront your accuser, challenge the evidence brought against you, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to driving with a suspended or revoked license and
Guilty.
defective or no taillights?
Guilty.
On the suspended or revoked license, your sentence is 12 months to serve on probation. You'll be released within 24 hours and you report to probation on Monday before 3 p.m. at 132 Mitchell Street. While on probation, you pay a $500 fine, and upon payment of that fine, your probation will terminate. Your license, of course, will be suspended in accordance with Department of Driver Services rules, and you will be eligible for reinstatement based upon the rules provided by the Department of Driver Services. With regards to defective or no taillights, your sentence is time served to serve 32 days, credit for time served 16 days. Thank you.
Thank you, Your Honor.
All right, position number 6. This is State versus Mario with 2 R's, last name Booth, 24 CR 4828J. And that's the only case we have, Mr. Booth. Mr. Booth has 6 traffic matters of which he's been accused. In this particular case, Mr. Booth, you've been advised of your right to remain silent, and your attorney is going to be Mr. Coleman. Mr. Coleman.
Good morning, Your Honor.
Good morning, sir. And Mr. Coleman, this is going to be a negotiated plea?
That's correct.
All right. Mr. Booth, please raise your right hand. Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, Your Honor.
Thank you. Ms. Mukherjee, what's the recommendation?
The state's recommendation for count one, no insurance, is 12 months to run concurrent with count four. For count two, driving without a license, the state's recommendation is 12 months concurrent with count four and a $500 fine. For count three, reckless driving, that will be 12 months concurrent with count four and a $250 fine. For count four, the willful obstruction, that is 12 months, served 30 days, credit for time served 15 days, balance probated, a $300 fine, and 40 hours of community service. For count five, the false information, that is going to be 12 months to run concurrent with count four. For count six, the driving, fleeing, or attempting to elude, that will be 12 months concurrent with count four and a $500 fine. I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
We will so stipulate. We would ask that the court accept the plea as negotiated. We would also request that the probation would either terminate or go non-reporting upon completion of the conditions, that probation fees be waived for a period of time.
Any objection, Ms. Mukherjee?
No objection, Your Honor.
All right.
Excuse me, Your Honor.
Yeah?
That's 12 months probation, not 12 months in jail, right?
Well, which one would you like?
Huh?
Which one would you like?
Oh, you know I wouldn't. I don't want to be away from my family for a year. That's what I'm just trying to be clear what's going on.
The offer is 12 months probation after you have finished out the 30 days, which you have done so. So you'll be released within 24 hours.
Okay, thank you, Your Honor.
The other thing I want you to remember is that your license will be suspended once you accept this plea and plead guilty to these charges.
How long will my license be suspended, Your Honor?
It will be suspended. Yes, sir.
I said how long, Your Honor?
Oh, it'll be in accordance with the department. Go ahead, Mr.
You would need to speak to the Department of Driving Services to find out exactly how long, sir.
Thank you.
It could be either 4 months, 6 months, or 12 months, depending on your driving history and on the charges to which you plead.
Okay, thank you, Your Honor. I just wanted to understand.
But you understand that your license will be suspended.
Yes, Your Honor.
Okay. Mr. Coleman, do you stipulate to the factual basis, venue, and ID?
We will so stipulate.
All right. Mr. Booth, have you consumed any medicine or alcohol?
No, Your Honor.
And have you understood the proceedings in your case so far?
Yes, Your Honor.
Are you satisfied with your legal services?
Yes, Your Honor, I'm very satisfied.
And if you decide to plead guilty to these charges, not only will points be added to your driving history, but your license will be suspended. And in addition to that, you would have to waive your constitutional right to a trial in front of a judge or a jury. You will not get the opportunity to go back to court with your attorney to confront your accuser, challenge the evidence brought against you, present your own defenses and arguments, and have the state prove the charges against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, Your Honor.
How do you plead to the following offenses? Operating an automobile on July 17th, 2024, with no valid insurance, no valid license, reckless driving, willful obstruction of a law enforcement officer, giving false information to a law enforcement officer, and fleeing or attempting to elude a police officer.
Guilty, Your Honor.
Count one on the no insurance is 12 months probation concurrent with count four. Count two, driving without a valid license, is 12 months probation concurrent with count four with a $500 fine. Count three, reckless driving, is 12 months probation concurrent with count four with a $250 fine. Count four, obstruction, is 12 months probation to serve 30 days, credit for time served 15 days, which he has completed. So he would be released within 24 hours to report to probation on Monday, August 5th, before 3 p.m. And that would be an additional $300 fine, plus 40 hours of community service with any nonprofit agency. that is not a church and not a school. With regards to giving false information to a officer, that would be 12 months probation concurrent with count 4. And with regards to fleeing or attempting to elude a police officer, that's going to be 12 months probation concurrent with count 4 with an additional $500 fine. So in total, Mr. Booth, you'll be on probation for the next 12 months, less 15 days. You'll report to probation. While on probation, you will pay a total of $1,550 in fines. You will do 40 hours of community service, and your license will be suspended in accordance with the rules of the Department of Driver Services. That concludes your sentence. Thank you.
Thank you. Have a good day.
You too.
Thank
Your Honor, he's also being held without bond on a felony case,
Oh dear.
so he won't be able to report to probation.
All right. His probation will will start as soon as he's released on his felony case. Mr.
Thank
Booth.
you, Your Honor.
Okay. I guess he won't be home with his family right away. Next case, jail court iPhone. Who do we have?
Position number 10, Mr. Jones.
This is State versus Eddie Lee Choates Jr., accused of theft by taking from July 17th, 2024. Mr. Choates, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Mr. Coleman in accusation 24 CR 4863G. And with regard to position 10, this is going to be a negotiated plea. Would that be correct, Mr. Coleman?
That's correct.
All right. Ms. Mokeke, what's the recommendation?
The state's recommendation is 12 months to serve 30 days, credit for time served 15 days, balance probated, stay away from the Easy Pawn Shop located at 21 Decatur Street, Atlanta. No further contact with Lucius Larkins, restitution to the victim in the amount of $900, and an anti-theft course. I would ask the defense to stipulate to venue, factual basis, and identification for purposes of the plea.
We will so stipulate. We would ask that the court accept the plea as negotiated. We would request that the probation either terminate or go non-reporting once Mr. Choates has completed the conditions, and that probation fees be waived for a period of time.
What is Mr. Choates' housing situation?
Mr. Choates, do you currently have a residence here in Lander Fulton County?
Yes, I do.
And what is it?
Oh, I stay in a rooming house, but it's a house in general.
What's the address?
561 Arthur Street, Atlanta, Georgia, and the zip code is 30310.
Okay, thank you. Mr. Coleman, you've already so stipulated. Mr. Choates,
Yes.
please raise your right hand. Do you
Just
solemnly?
1 second, Your Honor. I would like to sound for the victim,
go ahead.
Mr. Lucius Larkins, and I'm looking at the notes right now. It does say that the victim did say that they don't want restitution, so I would move to remove the restitution from the plea offer.
All right, well, that's one plus factor. Mr. Choates, do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes, correct, I do.
Okay,
Yeah, I'm asking that the restitution on the plea form be stricken as well.
oh, yes, I've stricken it, but he'll still be required to do the anti-theft class.
That's fine.
Okay, so Mr. Choates, have you consumed any medicine or alcohol?
No, I'm not under any influence of anything.
And have you understood what's going on in your case?
I surely do.
Are you satisfied with your legal services?
Yes, I am.
And has anybody forced you to take this plea today?
No, they're not.
If you decide to move forward with this plea, you would have to give up your constitutional right to a trial in front of a judge or jury. You will not be able to confront your accuser, challenge the evidence brought against you, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, I am.
How do you plead to one count of theft by taking from July 18th, 2024?
Plead guilty.
Does he have any other holds, Ms.
Nothing I'm aware of.
Ms. Mokeke and Ms. Tyson, before I move forward with his probation requirements?
No, Your Honor, I don't see any holds for him.
All right. Mr. Choate, your sentence is 12 months to serve 30 days, credit for time served 15 days. You'll be released within 24 hours, and you must report to Fulton County Probation on Monday, August 5th, before 3 p.m. And the probation office is located at 132 Mitchell Street in downtown Atlanta. While you're on probation, you will report every month, and you will enroll in an anti-theft class within 45 days of being released. Once you have completed the class and provided proof of it to your probation officer, your probation will then be non-reporting. At all times, you are to have no contact with Lucius Larkins and to stay away from the Easy Pawn Shop at 21 Decatur Street in Atlanta, Georgia. Thank you.
Thank you.
Thank you, Mr. Choate.
Next case, please.
We have positions number 20, 27 through 29. Hensley.
Twenty-seven through 29.
This is State versus Joshua Hensley. Mr. Hensley has two open cases, 21 CR 1913Y, battery family violence from April 15th, 2021. He has a second case, 24 CR 4865Y, giving false information to an officer and willful obstruction of an officer from October 3rd, 2023. And he has a bench warrant, 24 FTA 978 from February 23rd, 2023. Does he have any other matters? Okay, these are the three cases with the State Court of Fulton County. Mr. Hensley, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and your counsel is Mr. Paul Bartel. Mr. Bartel, 27. Yes, sir. What's the announcement?
Well, Your Honor, on 27 and 28, Mr. Hensley is wanting to go forward with a plea on both cases. And he understands that number 29 would be null pros. I've relayed to him the recommendation that the state would be making. And he is asking for a different sentence, Your Honor. I think because of some background on the case, I think I'll let the state go ahead first, and then let the state know, let the court know what Mr. Hensley told me.
Well, actually, I'm kind of curious as to what exactly is the objection to the state's recommendation. I believe it is obviously probation, but I don't believe there's any additional jail time.
Well, can you hear me okay, Mr. Hensley?
Yes, sir.
Okay. I did discuss the cases yesterday with Mr. Hensley. He gave me some history. He had two cases arise in 2021 with the alleged victim, Ms. Bostic. And this case, the date of arrest, I believe, was April 1st, 2021. In October, he had another charge involving Ms. Bostic. He was in jail on that case. It was a felony for about 109 days, I believe. And what Mr. Hensley told me is that he was told when he entered a plea to that case in 2022 that it would cover both of the pending cases that he had open at that time.
May we have the felony case number?
Yeah, it's, let's see. Actually, I'll have to go get that on my.
Give me a moment.
I may have it, Your Honor. Okay, it's 21 SC 180135. And I haven't been able to find any kind of transcript, but Mr. Hensley told me that he was advised at that time that when he entered a plea, it would cover both cases. And he served,
Meaning what? Meaning the October 3rd incident?
Yeah, well, what he tells me is that he was told that that plea would handle this case that's here on the calendar and the October case.
All right.
Again, I don't have a plea transcript, so I don't know, but that's what I'm told by Mr. Hensley. And he did serve a couple of years on probation for that. And his belief and what he's wanting to ask the court is just a time served sentence on both cases. I have advised him what the state's offer is and what the court's common practices is, but that is what he's wanting to ask the court for. And that's
I've done anger management already for the same person. I'm in here right now, finishing my days of 3 years of probation for the same person, and they're trying to offer me the same thing to come back out to the world to. I have a family, I own a barbershop, and I just want my life back. I'm trying to leave Atlanta, Georgia, to get my life together. This girl has ruined me. I took my sentence. I've done everything y'all asked me to do, and I just want to be free and live my life. I've done my anger management classes. I've gave 3 years of probation. I've done 109 days, and I'm currently doing more days for this girl right now. Every other charge that I do have was because of that, from me lying about my identity, trying to work still out there with warrants. Because
Sir, I would advise
situation. So I just want my life back.
I'm sorry, I'm just trying to go through the felony disposition right now, and I am seriously looking for anything that says that the incident from April 15, 2021.
It's like, how would I be sick? How would I be? That was before October. So how would I still have this case open? And I went for the felony charge, and they sentenced me for that. When I went in there, they told me all this will be put together. The prosecutor said all this will be put together. That's why I took the plea deal.
I believe I can answer that. Number one, the DA's office doesn't have the jurisdiction to offer a global recommendation on an open state court case. If they even had tried to do something like that, there would have been something either in the indictment, which I've already checked, and there's nothing in the signed indictment that was signed by Mr. Hensley, or in the sentence, which, Your Honor, feel free to look.
No,
feel free to look that over.
Just
But
one second.
that is not there either.
Ms. Falk.
Yes.
Mr. Hensley, you don't interrupt while she's reciting. All right? Just like your attorney is not interrupting her. I apologize, Ms. Falk. You were saying that he has to sign off on what?
There is nothing either in the indictment, which Mr. Hensley signed, entering his plea of guilty, nor the sentence sheet that at all indicates that these cases, the felony and misdemeanor case, were joined together. In addition, despite what Mr. Hensley says about having completed family violence intervention program, his probation violation in felony court, which led to him being held here on a probation violation, was in part because the defendant was terminated from the family violence intervention program due to poor attendance as of December 12th of 2022. That's laid out in his probation warrant on that 21 SC that was filed on January 24th of 2023 and signed by Judge Edwards in February of 2023.
Well, I already been sentenced on it, man. Like I'm finishing up everything right now.
All right. Mr. Bartel, I'm not persuaded that the case 21 CR 1913Y was addressed in the felony case. Number one, it was not expressly stated in the disposition, which goes through a lot of details. And I don't have any indication. And even with Mr. Hensley's claim that he has completed his sentence satisfactorily, that is contradicted by the fact that he had a probation violation matter in his felony case. So at the present time, he is free to go to trial on these open cases, or he could consider any other option. So, Mr. Bartel, how would your client like to proceed?
Well, Mr. Hensley, you could either accept the judge's sentence or put these down for trial, or if you want to talk to me in private, we can do that and come back to the case.
I just wanna, Your Honor, I'm just asking for, I'll give a guilty plea. I don't want no more probation. That's all I'm
No,
asking.
you're getting probation.
Well, then I'll take it to trial.
Okay.
All right, we'll put both of them down for trial, Your Honor.
All right, this will be a waiver of arraignment. And there's no additional jail time if he goes on probation, but and he'll need to make sure that he completes probation satisfactorily. But in his but as the defendant has decided to plead not guilty, Mr. Bartel, please submit a waiver of arraignment for positions 27, 28, 29, and all three cases are further notice for trial.
I will do that, Your Honor. Thank you.
Thank you, Mr. Hensley. Next case, please.
We can go to position number 48, Mr. Weems. That's a breakout. Breakout.
State versus Thomas Weems, accused of 3 counts of battery, family violence, and 2 counts of cruelty in the 3rd degree from July 17th, 2024. Mr. Weems, your case number is 24 CR 4842G. You have been advised of your right to remain silent, and your attorney is going to be someone seated next to you.
This is Mrs. High's case, Your Honor.
Yes, Your Honor, I asked for a breakout for this one, and I would prefer a clear courtroom.
Is the room, I can't see the rest of the
They
courtroom.
are doing that now.
I'm sorry?
Yes, Officer Norris is clearing the courtroom now.
All right, Miss Lewis, if you could place courtroom 2, myself and Miss Falk into a breakout. And Miss Tyson, please, or Miss Tyson, if you want to give me his GCIC right now.
You got a problem. The client got a problem. I will take him back.
Thomas Weems,
Thomas Weems.
before I go into a breakout.
23 arrest cycles beginning in 2003. I have a felony conviction for theft by shoplifting from September of 2023. He received probation for 10 years, community service 40 hours. Let's see. I'm not sure. It looks like we have a pending driving while license suspended or revoked out of Dunwoody. Arrest date was January 27th of 2023. We have a failure to appear from 2023 and 2022. There's another driving while license suspended or revoked from January of 2023 out of Holly Springs Municipal Court. There's another misdemeanor conviction for knowingly driving motor vehicle on suspended, canceled, or revoked registration, and driving while license suspended or revoked.
Okay, that's good.
Yep. Okay.
Thank you.
Mhm.
All right, Miss Lewis, if you could place courtroom 2. We are going to resume with our hearing on 24 CR A4842G regarding Thomas Weems. And with regards to that matter, Mr. Tay, do you confirm that you are filing a waiver of arraignment, or shall I arraign your client's case? Please unmute, Ms. Tay.
I'll file a waiver of arraignment.
All right. Now, as we have already covered, Mr. Weems has presently got a split bond with count 1, count 5, and count 6 being surety bonds, counts 2 and counts 3 being a signature bond through a pretrial, and he also has a Cherokee County hold. As instructed by the court, what is the request for a bond modification?
Your Honor, I am requesting that the $2,500 surety bond and the $1,000 surety bond and the third $1,000 surety bond be converted to a signature bond through pretrial services at whatever level Your Honor deems appropriate. I believe you had set a pretrial bond at level 3 for the other charges, which I guess are merging. But I would just ask for a signature bond through pretrial services, even if it has to be at level 3 or 4, due to the fact that he has absolutely no violent criminal history at all.
Thank you. Ms. Polk?
Your Honor, I would like to point out that this defendant does have 2 cycles from outside of Georgia. Both are in Florida. The most recent one was May 6th of 2020, where he was sentenced for, it looks like, dealing in stolen property, false verification of ownership, and was provided a criminal sentence as to that. Additionally, he has now 22 cycles, I believe, here in Georgia, ranging with a most recent September 8th, 2023 failure to appear. The reason I point that out is because that goes directly to the defendant's likelihood of reoffense, as well as the fact that he has a multi-state offense, which goes to possible flight. Additionally, the fact that he has the failure to appear from September 8th of 2023, a previous failure to appear January 30th of 2023 out of Cherokee County Sheriff's Office, a failure to appear before that, Morrow Municipal Court, December 7th of 2022, all add up to an individual who is not likely to return to court. We believe that this recommendation, the previous order, was based in part on the defendant's failure to appears, of which he has 3 in the last 2 years. And so for that reason, we would ask the bond remain as set. We are also seeing a fugitive from justice warrant out of Georgia State Police Department in 2017. And as you know, the defendant also has a hold from another county that he is currently here in jail on, as well as this current charge out of Cherokee County. We additionally have had an opportunity to speak with the victim's mother. She did, at the time that we spoke to her, state that this is not the first time her husband has threatened her daughter, that they are not biological family members, but he has threatened her in the past. And for that reason, although he has not been violent with her, for that reason, she wanted no contact and from the defendant to stay away from the residence. She is okay with third-party transfer of their other 2 children with whom he shares. And so we would ask at this time the bond remain as set.
Mr. Tay, I understand that you are asserting that this is corporal punishment, but that is a jury issue. And whether it's corporal punishment or whether it's battery family violence would be a matter to be fleshed out during the course of a trial. The bond modification is denied. The bond as set forth is reasonable under the circumstances and based on the egregious allegations set forth in the warrant. This case is going to be further noticed for trial. In the event that Mr. Weems makes bond, he will be required to comply with the conditions of the bond. But upon release, he would have to be transported to Cherokee Police Department. Thank you.
Next is probation number 4, Joshua Smith.
This would be our probation matter. Would that be correct? Jail code iPhone?
Yes.
Okay, so this is positions 3, 4, 5, and 6. Officer Allen, oh, Brooks, okay, you're still with us. Good, thank you. This is this Joshua Lamar Smith?
Yes, ma'am.
Mr. Smith, Joshua Lamar Smith, is that you?
Yes, ma'am.
Okay. Mr. Smith, you have a probation revocation matter. Your case number is 21 CR 000050J, in which you were convicted of battery, family violence, and cruelty in the 3rd degree. You've got another case, 23 CR 4730J, in which you were convicted of criminal trespass causing damage to property. You've got 2 probation violation matters with respect to these 2 cases, 24 PV 1275 and 24 PV 1276. Please remember that you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is Ms. Atay. Officer Brooks, you've already been sworn. What is the reason for the state seeking a revocation, and what's the recommendation?
Yes, Your Honor. For the 21 CR 000050J for the battery family violence, he last reported January 22nd of 24. He reported only a total of 3 times. He did not enroll in a domestic violence counseling class. He only has 24 days remaining on probation, so we're recommending time served.
And with regards to position 4, the criminal trespass?
Yes, Your Honor, on that case, same amount of time for reporting. He never enrolled in the anger management program. He has 61 days remaining. We are recommending that he continue on probation since he does have time to complete the 2-day anger management requirement.
All right. Ms. Atay?
No objection to time served on the 50J case and the 2 days anger management within the 61 days on this 30J case.
All right. On position 3, this will be recorded as a probation violation, and his sentence is commuted to time served, and that closes out that case. With regards to the criminal trespass, he still has 61 days left to complete his 2-day anger awareness class. If he has no other cases holding him, does he? Anyone can tell me? Does he have any holds?
I need to check.
Ms. Lewis, do you know if he has any other holds?
I'm looking out.
No, Your Honor, he doesn't. Just probation.
Then he will continue on probation. He will be released within 24 hours, and he must
has probation. Is this Joshua Smith?
Joshua Lamar Smith, yeah.
Yes, he has a probation. Did he take care of his probation on revocation?
Position 3 has been closed out, commuted to time served. And so that leaves us with position 4, where it's recorded as a probation violation. He will continue on probation. He will report every week, beginning Monday, August 5th, before 3 p.m. And he'll be required to enroll in a anger awareness program and complete that. As soon as he's completed the anger awareness program, then his probation will terminate.
Because he do have a felony.
He has a
probation
felony.
hold.
Oh, he has a felony hold.
He has a felony probation hold too.
Okay. In that case, the court will disregard the recommendation for him to enroll, and his probation is revoked, and he will complete the 61 days in jail. Thank you. Did you get that, Mr. Smith?
Yes, ma'am.
All right, thank you. Miss Officer Brooks, that's a revocation of his probation and to complete 61 days in jail.
Thank you, Your Honor.
Next, we go to position number 41, Mr. Spalding.
May I be excused, Your Honor?
Ms. Brooks, thank you so much. Have a good weekend. Thank you.
You too.
I'm sorry, Deputy, could you give me that case number again?
41.
41, thank you. This is Shaquille Xavier Spalding Allen, accused of theft by shoplifting from July 10th, 2024. That's the only case we have with him this morning. 24 CR 4612D. Mr. Spalding Allen, you've been advised of your right to remain silent, and your attorney is Ms. Atay. How are we proceeding, Ms. Atay?
Your Honor, it's a not guilty and a bond argument.
All right. Will you be submitting a waiver of arraignment?
Yes.
All right. Mr. Spalding Allen, your attorney has filed a not guilty plea, and your case is going to be further noticed for trial. Presently, he does have a surety bond. And yes, ma'am, what's the argument?
Your Honor, he is 24 years old. He has lived in Georgia all his life. He is experiencing homelessness right now. He's been in custody for 23 days on this theft by shoplifting charge. He has a hold in Chatham County. I would just ask that this be converted to a signature bond through pretrial services due to the nature of the allegation. It's a theft by shoplifting. He has been in custody for 23 days. He does need to go take care of the hold in Chatham County. And he's not a flight risk, Your Honor. He's lived in Georgia his entire life. He has strong ties to the community. He has a father in Savannah, and he has a brother and his mother in Georgia. And nothing further.
Okay. Ms. Tyson, may I have his GCIC? I'm sorry, I didn't do the original bond, so.
And Your Honor, is probation still here? Because there is a pertinent fact that we need to address.
We
I
have
see JCS probation, Miss Thomas, but
yes.
I'm not sure she already left.
No, Miss Thomas should be here. It's
Okay.
just Officer Brooks has left for the revocation hearings.
Got it.
All right. Mrs. Thomas with JCS probation, are you available?
Yes, Your Honor. I was trying to find my mute button. I'm sorry.
All right, no problem. All right. Yes.
And while pretrial is going through the history, I would ask probation if they could pull up 24 CR 003843Y.
Thank you. Ms.
Thank
Tyson?
you.
24 CR 00.
00.
Oh, could you put it in the chat to Ms. Thomas?
Yes, I
Thank
will.
you.
My
Okay.
apologies, Your Honor.
That's okay. Jazz fingers sometimes. All right. Ms. Tyson?
20 arrest cycles beginning in 2015. Last arrest was June 16th, 2024. Let's see. I'll waive sounding on that charge, Your Honor.
Okay.
We have a felony conviction out of, looks like Chatham County for theft by taking, theft by receiving stolen property, receipt, possession, transport or found by convicted felon, a felony first offender, purchase, possession, manufacture, distribution, or sale of marijuana, given false name, false statements or writings, conceal facts or fraudulent documents in matters of government, possession of Schedule II controlled substance, forgery in the second degree. The disposition date on that case is October 2022. We have another felony conviction out of Chatham County for enter an auto willful obstruction of law enforcement officer. Looks like 2 counts by receiving stolen property. Like
That's,
he received first offender treatment on that case in 2020, and it was revoked October 2022.
and that was Chatham County.
Yes, that was Chatham County, yes.
All right, that's good. Thank you so much.
You're welcome.
Ms. Falk, do you have a response to the request for a bond modification?
Yes, Your Honor. We ask that bond not be modified at this time for several reasons. One includes that the defendant entered a guilty plea as to sexual battery on July 2nd of 2024 of this year. The defendant was given 12 months, served 34 days, credit for time served 17 days. So that's why I was asking for probation's input, because he was released and then rearrested within, let's see.
7 days.
Yep, within 7 days for these new offenses. I don't even know if he had time to actually meet with probation, or if probation knows that he was under that sentence, so a probation warrant can be issued, because technically he would be in violation of his open probation. Additionally, this defendant has 3 prior theft by shopliftings, all out of Chatham County. We were attempting to get this case transferred, but given that the DA's office wanted the actual Senate sheets, we were willing to go forward with this case. However, this does give us the opportunity now to provide those Senate sheets to the DA's office for transfer. But there were a theft by shoplifting where the defendant entered a guilty plea on in a 2019 case, as well as a theft by shoplifting where the defendant entered a guilty plea in 2018, and a theft by shoplifting where the defendant entered a guilty plea in 2018, and that was accompanied by willful obstruction of law enforcement officer and obstruction. So
that's good. Thank you, Ms. Falk. Bond modification is denied. And Ms. Thomas, if the state is planning to revoke the probation, please advise Judge Morrow, because he was the one who issued the disposition. Thank you. Next case, please.
Thank you.
We can go to position number 42, Mr. Thornton. Third row, there. Come on. Hey, you gotta go to the third row. Third row that way. She cannot. He's currently doing somebody.
This is State versus Romero Thornton. Is this Mr. Thornton?
Yes, ma'am.
Okay. Case number 24 CR 25858, accused of criminal trespass, August 4th, 2022. Mr. Thornton, you've been advised of your right to remain silent, and your attorney is Mr. Tay. Mr. Tay, I'm so sorry. I don't have your announcements. How are we proceeding with this case?
I sent my okay.
I may not have printed it, so it's my bad.
Okay, Your Honor, it's a not guilty plea.
All right. And will you be filing a waiver of arraignment?
Yes.
All right. Mr. Thornton, your attorney will be entering a not guilty plea on your behalf, and this is going to be further notice for trial. Is there anything else to address?
No. Not from defense.
All right. Thank you.
Next, we can do 51 and 52, Mr. Williamson. And it's a non-negotiable plea.
And Your Honor and Ms. Fox, the only thing that's not negotiated about this is that is the stay away from MARTA. He was at that time, he had a 6-month ban from MARTA, and he wouldn't have a MARTA ban. So I would just say just in compliance with any active MARTA suspension instead of a stay away from MARTA based on this.
Any objection from the state? I don't have access to the suspension records.
I'm just looking at the report, Your Honor. So if you'll just give me a moment so I can check and see how long they added to that suspension. Nope, says in the police report, Williamson was issued a MARTA suspension notice number 72461 for permanently banned. So.
I would, I
the
would
state
just,
is not
I mean,
going to change our recommendation.
if he is banned, I'm just asking for it to be in compliance with any MARTA ban or suspension.
He's got a permanent ban. So there is no any, there is a permanent. I don't know what
Well-
other synonym there would be for that.
Well, he tells me that it was a 6-month ban. There could be something that's not correct there. If there's a ban, then if he goes there, he can be arrested again. I'm just asking for it to be in compliance with any MARTA suspension or ban. Those things can change too.
Well, since it's non-negotiated, the state, it is up to the court as to determine whether to do a suspension in compliance with any pending MARTA suspensions or a MARTA suspension as to all MARTA stations for the period of probation. Given the facts on this case, I would ask for it to be also a permanent suspension.
Let's move forward. So this is going to be a non-negotiated plea. Mr. Williamson, you've been advised of your right to remain silent, and your attorney is Ms. Atay. And we are going to move forward with a non-negotiated plea hearing. May I place you under oath? Do you solemnly swear and affirm the testimony you provide will be the truth to the best of your knowledge?
Yes.
All right, you need to speak louder since you're speaking through a mic.
Yes.
All right, thank you. Okay, you can put your hand down. And Ms. Fulk, what's the recommendation?
Your Honor, state's recommendation on this case is a 12-month sentence, served 26 days, credit for time served 13 days, from July 19th, 2024 to today, balance suspended, and stay away from MARTA located at we're asking actually to modify that to stay away from all MARTA stations. The report essentially says that the officers were patrolling May 25th, 2023, observed the defendant who was on a MARTA train after being issued a criminal trespass warning on 4/17/2023 for a policy violation. The defendant was then issued a criminal trespass. When they pulled up his information, it showed that he had suspensions in February 10th of 2023, February 15th of 2023, March 11th of 2023, February 26th of 2023, and May 25th and April 17th of 2023 to resume June 24th of 2024. At that point, he was issued a MARTA suspension number 72461 to be permanently banned, and was advised of that suspension notice on May 5th, 2023.
Do you have a copy of that?
I do have the police report that I can send to Your Honor and to Ms. Atay. So essentially, at the time he was banned on this case, he had been banned previously all the way up until July of 2024. So I believe that is why at the time they just issued him a permanent ban.
All right. Oh, if you can just screen share the report also, if you have it.
I can.
Ms.
If they allow me to do screen sharing, absolutely.
Ms. Lewis, please.
She should be able to do it.
Try it, Ms. Paul.
It says host has disabled participant screen share.
Let me just do it for this one more time.
Thank you. And Your Honor, this is the portion of the report I was citing to.
Could you scroll up to the first page of the report, please?
Absolutely.
Thank you. Okay. All right, this is from the May 5th, 2023 incident and involving this defendant. Okay, and let's scroll down then to the page, to the pertinent provision that, okay, there we go. Permanently banned, was advised of the MARTA suspension notice, the appeal process and so forth. Okay, Thank you.
Thank you, Your Honor.
And we can stop screen. All right, Miss Matei, yes.
Yes, Your Honor, it does state that there's an appeal process there, so, I mean.
This was from last year, so you tell me, how would you like to proceed?
Well, Your Honor, it's a time served offer. I'm just saying that I want him, if he's not banned from MARTA, to be able to use MARTA.
Okay.
But that's all, that's the only aspect that I'm just asking, instead of saying stay away from MARTA, just say comply with any MARTA ban. So that if he does appeal and needs to use public transportation, he can do that.
The sentence sheet is going to say is to stay away from all MARTA property in accordance with the permanent ban.
Okay.
Are we still proceeding?
Yes.
So, Mr. Montez Williamson, I believe I already placed you under oath. Have you consumed any, I'm sorry, Ms. Atay, do you stipulate to the factual basis, venue, and ID?
Yes.
Okay. Mr. Williamson, have you consumed any medicine or alcohol?
No, ma'am.
Have you understood the proceedings so far?
Yes, ma'am.
And are you satisfied with your legal services?
Yes, ma'am.
If you decide to accept this plea, you would have to give up your constitutional right to challenge this charge in a court of law. You will not go back to court. You will not face your accuser in front of a judge or a jury. You will not be able to challenge the evidence presented against you, present your own defenses and arguments, and have the state prove the charge against you beyond a reasonable doubt. Are you prepared to give up these rights?
Yes, ma'am.
How do you plead to one count of criminal trespass from May 5th, 2023?
Guilty.
Your sentence is going to be 12 months to serve 26 days, credit for time served 13 days. You will be released within 24 hours unless you have any other holds. And then you are required to stay away from all MARTA property in accordance with the permanent ban that was instituted on May 5th, 2023.
And the balance is suspended.
Correct. The balance is suspended. Thank you. Mr. Williamson, right now you're required to stay away from all MARTA property. If you go back to any MARTA property and you're arrested, please be mindful that you will be back in jail. Thank you. Okay, next case, please.
She would answer, but I'm.
That's up for courtroom too.
Is that all for courtroom 2?
Yes, Your Honor.
Okay. Do I have Amar Bolden and Darius Lindley?
Yes, ma'am. Amar Bolden is present.
Now you need to start your video and make sure you're addressed.
Yes, ma'am. I don't have no shirts on. I ain't gonna lie. I got a tank top on. I can keep the camera like in my face.
Go put on a jacket. Otherwise, I'm going to remove you from Zoom.
A jacket. All right.
Stop.
Give me 1 second.
Stop
I
your
don't want to
video.
get removed
Okay.
from Zoom.
And mute his screen and make sure. Otherwise, the bench won't move forward because he does not address. Darius Deshaun Lindley.
Yes,
Are
ma'am.
you- Okay, good. Mr. Lindley, you have a bench warrant in case 24 CR 003-145A. You were accused of simple battery, family violence, and criminal trespass. And it appears that you failed to appear in court and a bench warrant was issued on July 3rd, 2024 by Judge Roth.
Yes, ma'am.
Okay. You have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney. If you cannot afford one, one would be appointed to represent you. Have you consulted with the Public Defender's Office?
No,
Yes, I've spoken with him.
Oh.
Well, I guess, do you recall speaking to the Public Defender's Office?
Yes, I'm sorry.
Okay. Ms. Atay, you represent Mr. Lindley. And what would you like to state?
Oh, so he has an FTA from July 3rd, 2024. He states that he didn't receive notice. We do have an updated address for him, which is the best address for him to receive mail.
Which is what?
It is 4431 Lamar Drive, Douglasville, Georgia, 30134.
303?
30134.
13. Okay, got it. Thank you. And when did we find out this new address?
Well, I spoke with him yesterday. I think he had another address where he was receiving mail, the one that is on file, 1475 Sand Bay Drive Southwest, apartment 1205, which he still could receive mail there, but he says it's just not reliable, the mail service at that apartment. So he would rather it go to this home address where the mail service is more reliable.
Okay, Ms. Falk?
Your Honor, I will say, give him credit where credit is due. I'm not seeing any previous FTAs since his first arrest in 2022. He is a multi-state offender, so he does have arrest out of another state, but there is no FTA as far as that is concerned. I will say he does have a probation violation on 2024, but was continued on his original probation on that case.
I'm going to set aside the bench warrant. Mr. Lindley, this is an open, active case in front of Judge Roth. If you fail to appear again, Judge Roth will simply issue another bench warrant, and the next time, just show up at the jail and then be prepared to address this case from the jail court. Do you understand?
Your Honor, I apologize. I thought this was Mr. Bolden. This is Mr. Lindley?
This is Mr. Lindley.
Okay, he has no previous history.
All right, so again, set aside the bench warrant. Make sure, Mr. Lindley, that your address is current with the clerk's office of Fulton County at all times. I don't care where you decide to live, but wherever it is, you need to make sure that the clerk's office are the first folks to find out where you live in writing. Otherwise, they will send your notices to the last known address. And if you receive it or if you don't receive it, that's entirely up to you.
Yes, ma'am.
But you are on notice right now that you're required to come down to the court and update your address change in writing, which you will do within the next 48 hours. Our offices are located at 160 Pryor Street, and you go to the first floor, you come there in person, and you submit your change of address in writing. I want you to do that so you have practice of what you need to do to make sure that we have your correct address.
Yes, ma'am.
All right, see you tomorrow or today. Thank you. Mr. Amar Bolden, have you found a garment to be appropriately dressed?
Yes, ma'am.
All right, start your video. It's amazing what we can find. Okay. State versus Amar Bolden, accused of battery, family violence, case number 24 CR 706E. With regards to Mr. Bolden's case. My goodness. He failed to appear on July 24th and a bench warrant was issued. He had a prior failure to appear on July 10th, 2024. All right. Mr. Bolden, you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. You have a right to an attorney, and representing you is it Ms. Atay?
Yes.
All right. Yes, Ms. Atay?
Your Honor, did you say he had a prior? I thought that.
I see two bond orders being forfeited, one from July 10th before Judge Morrison. And I don't know whether This was the same matter. Let me see.
I believe the second one is when I went into the courthouse to get this court date that we're in at the very moment established. I don't know if that's how it popped up, but I believe I went on the 24th to clear up the warrant. And they reset this case for the day.
Yeah, I don't think he has.
Yeah, there was it was Judge Morrison's bond forfeiture. Yeah. All right. And
Your Honor, so this is from the FTA on July 10. I did see that there was a return to sender with the address of, I mean, it has an address on it that doesn't exist, 187 Maury Avenue Northeast. There's no such address. He does have an updated address.
Hang on.
It is, I think, 2025 Peachtree Road, apartment 301, Atlanta, Georgia 30309.
Ms. Falk?
Yes, Your Honor. I'm not quite clear on why the address he provided did not match.
That's the address that was provided.
I wasn't.
That was the address that was provided at the booking information.
Okay.
Yeah, and I wasn't asked. They just insinuated where they arrested me at was where I lived at. That's probably why they took that address and it didn't exist, or I didn't live there. But I wasn't asked upon arrest. If I was, I would have provided the address that I live at.
Anything else, Ms. Falk?
No, Your Honor, other than to say that I do know that normally when a bond order is entered, part of the discussion at first appearance is the fact that the defendant needs to update their address or provide an address if they don't have one. Neither of these were done. I will say this is the defendant who, again, has a history, but no previous FTAs.
Anything else, Ms. Atay? I'm sorry, I didn't hear you.
No, Your Honor, I would just ask that you set aside the bench warrant.
This was a charge of battery, family violence, in which the address was provided 187 Maury Avenue. The allegation.
Reset. To the next court date. Let's go. It just said reset. I don't know how many.
Yo, come on, man.
No, not now. Not now.
I'm not going to set aside the bench warrant. The warrant has to be executed. Mr. Bolden has to report to the jail by Saturday morning at 9 a.m. Upon booking in, his bond is going to be amended to $2,500. It's going to be a signature bond through pretrial services, level 2. He will have to report to pretrial twice a month. No further contact with Shana Lateya, and to provide his current mailing address within at the time that he's booked in. No illegal drugs, no alcohol, and no weapons. Mr. Bolden, do you understand the court's ruling?
No, I do not.
Well,
understand it, Your Honor. Can I have
your bench warrant is not set aside.
Can I, like,
Ms. Atay, would you like to call him and speak with him?
I have his phone number. I can call him. I would say, I mean, it's his very first FTA.
Understood.
The address, you can see in Odyssey, it was returned to sender. So I don't understand why this very first FTA in his life, where you can see it was sent to the wrong address, is not being set aside.
because the court is not satisfied with his explanation of how that Maury Avenue address came on the record, the warrant expressly states that she lives with him at that address at the time that he was booked in, for him to make the assumption that the police assumed that address as opposed to him providing an updated address so that he could receive notice of when to come back to court is pretty egregious.
Well,
So
no one
I
lives
am,
at
no,
the
Ms.
address
Ate,
that
no,
was
Ms. Ate, I've ruled. He needs to come to jail, be booked in, released on a signature bond, and he will report to pretrial twice a month and have no contact with this lady and make sure that he provides us with his current mailing address. It's up
I
to,
provided you with a current mailing address.
I'm done.
And no one lives at this address that it was mailed to. No, that address doesn't exist anyway.
It have 187 Maury Avenue on the warrant. I'm just going by that. If that was
It was mailed to 187 Maury Avenue Northeast, which does not exist.
your client is required to make sure the court has his current mailing address. We are moving on. Thank you. Mr. Bolden, please speak to your defense attorney and she will explain to you what you're required to do. Thank you. All right, moving on to our competency calendar. All right.
It's a fucked up ass system.
All right, the bond is just, the signature bond has just been revoked. This will be, he'll need to report to jail, but immediately, and Judge Morrison will address any bond modification. You can forget the signature bond, Mr. Tate. Okay, moving on. Ms. Lewis, can you please put us in a breakout for the competency calendar? And who's going?
Your Honor, good afternoon. If I may, this is Attorney Mide Olaloye. Your Honor, I didn't hear my client's name on the state all-purpose calendar. He's Mr. Tremaine. He was position 43, Tremaine Watts. He has 4 cases. I represent him on 1, but I didn't hear his name called at all.
Was he even pulled up? Deputy in courtroom 2, do you have Mr. Olele's, what was that name again, please? Position
Tremaine,
Watts?
last name Tremaine Watts, position 43 on the state all-purpose calendar.
Yeah,
No,
I see it.
there's not a deputy here.
Yeah, actually, Your Honor, he's position 43 through 47. There are several positions on the state all-purpose calendar that were never called.
Oh yeah, I was going to go over that once we do the calendar status. Who do we have at ACDC?
That's Ms. Mara, Your Honor. She's on the 11 a.m. calendar.
Oh, okay. Mr. Olele, I could not tell you, and there's no deputy right now to give me an explanation. If you want to wait till I'm done with my competency cases, then I'll be glad to revisit. But right now, I'm moving on to my breakout cases.
Okay, thank you, Your Honor.
All right, sorry about that. But if there's a deputy in courtroom 2 who can reach out to Mr. Olele, am I butchering your name? I'm sorry.
It's fine. It's Olaloye. That's fine, Your Honor.
Okay.
There's also another private attorney out here as well, Mr. Render. I don't think his case was ever
All right,
called.
private counsel, if you would like to put your phone numbers directly to courtroom 2,
Sure.
as soon as in the chat, hopefully the deputy will catch that and give you some update as to your client's cases.
Thank you, Your Honor.
Ms. Lewis, may whoever is going into the breakout for our competency calendar, please start your video so that Ms. Lewis can place you.
I can go into the breakout room on my laptop, Your Honor.
Okay, sir.
Your Honor, so we're gonna do Miss Morrow first?
Yeah, we're going to go into the breakout to do that. So watch the screen and we're going to go into a breakout.
Okay, thank you.
Are you doing the 5 p.m. Felony ORCA bond hearings?
Yes, I am.
Okay, I'll see you then also. But right now, let's do this one, okay?
Okay.
So watch for the message.
Judge, do I need to put ACDC in there too, or do they need to stay out to y'all
No,
address?
put ACDC in there.
Okay.
Ms. Mokeki, Ms. Falk, Ms. Kia Burgess, And as soon as Mr. Bartel pops up, put him in there too.
Okay.
Thank you.
Your Honor, I'm going to set Ms. Makake free on having to go to competency calendar. So she can hold off while we go in there if she
Oh.
needs to just get a drink or grab a bite while we're
Oh,
doing
please,
that.
yeah, definitely go
Thank
ahead.
you.
If anybody needs a break, go ahead. Did Mr. Dennis Murphy show up or is he left?
He was on the line. I think he's popping on and off. If he comes back on, I'll put him in there. I just want to make sure I got everybody in here.
50
Hey, Mr. Murphy, they're already in the breakout room. I'm gonna put you in there, okay? Attorney Ole?
Yes, ma'am.
Do you know what you plan on want to do with your case? Do you want to, do you
So
want
it's kind of in a weird position because this case was contracted 2 years ago. I never met him, so I was hoping to at least maybe get an offer, maybe talk to him, see if we can resolve it today. But it's I think the tricky thing, because I never met him, because I never had his contact information when it was first contracted out to me. So I haven't even spoken to him. So I was hoping to at least speak to him, get an offer from the state, and speak to him and see if we can resolve it. Because although he has 4 cases, I represent him on 1. If possible, I would have tried to see if we can resolve all of them. But
is he deputy in the courtroom to explain why Mr.
so there hasn't been a deputy. Oh, sorry. Go ahead.
So he didn't know if he was represented or not. I did see an entry. I did see your name there, but I wasn't sure what cases you were representing him on. He did waive his appearance today for me, but I'm sure the deputies can bring him in here and
We brought back already.
so. Okay, they can't bring him here.
So I guess we just have to be a reset.
I'm just saying he wasn't brought here because he waived his appearance for.
Okay. Do you represent him on the other ones?
Well, I'm a public defender, so I would if you're not.
Right. Yeah, I only represent him on 1 because that's the one that was contracted out a couple of years ago.
Which one?
The first one, position 43.
The 22CR001417B.
Yes, ma'am.
He's private.
Are you private attorney or are you the conflict?
Private.
Oh, private.
It was conflict. Right. It was conflict.
See, I know I was on credit.
I mean, only thing that can happen is that I can send you a copy of what the state offered to your email, and we can reset it to Monday's calendar.
Monday being that
6.
I'm in court in Coweta all day.
Okay, do you want to reset it a week out to this time next week?
This time next week. I'm in Court of Appeals, unfortunately. The 8th. Have an oral argument next week.
And there's no way the deputies can go and get them at this point.
They're here.
We're trying to get Mr. Watts into the court where he has a private attorney.
Okay, Lola Lloyd.
Do you think we can get him?
Oh, okay, Lola Lloyd. You should have been here on time, Mr. Lola Lloyd.
I was here on time. I've been here since the very beginning.
From the beginning? So
I've been here since 9 o'clock.
I told you both been here. Where's the judge?
The judge, they're still in the breakout room. They're still in the breakout room with the competency counter. Is there any way? Because she still got to go over the counter and she still got to talk about some of the cases that were not addressed today. Because I think we still have another private attorney.
We're not done.
So I'm just asking.
Yeah, we're not. There are a whole lot of blanks on the calendar.
So is that a yes or no?
I'll go get him.
Thank you.
Appreciate you, Deputy.
you.
Client.
Mr. Renner has a client as well. I'm not sure if he.
Yeah, Mr. Renner, who's your client?
Mr. Timothy McGahee, he's also.
Yeah, he's 36 and 37.
He's position 37. Can you go get him too?
He's on the Zoom call.
37. Oh, he's out. Oh, so since he made bond,
okay.
If he's out, none of his cases reset to further notice back to the original judge assignment, which will go back to Judge Morrison courtroom. So he's been released.
If they come back, maybe they're done with the competency calendar now.
So that's the reason why your client is I don't see him. He's on one of these iPhones, Mr. Render?
Yes, Your Honor. I mean, yes, yes, she is, Ms. Lewis.
Okay. Judge, I was just trying to clear up some things, trying to get people in the courtroom for you.
What people you missing?
Well, I'm not.
All right.
On the calendar. Mine will reset, so there's no problem with mine.
Okay.
So for clarification,
Mr. Render, is your client resolved?
I think his client
he's
bonded
bonded out
out.
the iPhone. He's on the
His
Yeah, I
camera.
think it's position 36.
His client bonded out. His client is released. Mr.
Okay.
Render's client is released.
All
That's
right,
position number 36 and 37. He made bond, he is released.
all right. Thank you, Ms. Lewis. Mr. Render, did you have anything else to add?
I wanted to address the situation, but I guess when he bonds out, it's automatically changed back to the other judge, and there's nothing for me to address.
Correct.
Wish
This
I'd known
case, this
that.
case is further notice for trial, for Timothy McGehee. And, if there are any, just make sure your client provides a good mailing address and that, he doesn't get into the bench warrant status again.
And that's what I wanted to address, Judge. But of course, it's already been resolved. But this was a situation whereby we were going to be on calendar call, and we weren't ready based on the fact that we had just received the discovery. But I had a conflict because I was specially set for a trial, and for some reason, I was set on a trial calendar and to come in when I was in trial. And so I tried to address it with the court and tried to address the bench warrant, but it didn't occur until, of course, he was incarcerated.
All
But I
right.
guess that's a moot point now.
Well, moot.
Yes.
Okay. All right. Thank you, sir. You're free to go.
All right.
And I guess we resolved it with Mr. Olaloye.
Yes, Your Honor. It's my understanding that they are going to have him brought over.
Okay. In the meantime, then, Mr. Coleman and Ms. Falk, I'm going to go over the calendar. Position 1, Darius or Darius Allen. What's the announcement?
Defendant was released on July 29th of 2024.
All right.
So we would ask that that be reset further notice.
Granted. Position 2, Anderson is reset jail jury.
He's also released, Judge.
Okay, thank you. Position 3, David Bailey is reset to August 8th. And oops, Mr. Murphy was here. I forgot to mention to him that he's appointed to represent Mr. Bailey. Position 4, Alfred Banks is a plea. Position 5, Kelvin Banks is reset to August 8th. Position 6, Mario Booth is a plea. 7, Marquita Brown is null pros. 8 was a plea. Position 9, Victor Bryant is released. Further notice, jail jury. Position 10, Choates was a negotiated plea. Position 11, Davenport.
Can we reset that to August 6th? It looks like his third case is going to be on calendar for that day.
August 6th, okay. 10, 11, and 12 are reset to August 6th. 13, Davis was a plea. 14, Davis was a plea. 15 and 16 are null pros. 17 and 18 were pleas. 19, Anthony Fambro.
That's reset jail jury.
All right, released further notice jail jury. And that's the same announcement for position 20.
Wait, Your Honor, was he, I apologize, was he released or is it just reset jail jury?
I'm sorry.
Reset jail jury. And I have a question.
So he was not released. I'm sorry. Okay.
I was just making sure. I didn't know where to put him.
No, he's still in custody.
Okay, that's all I wanted to know. Thank you.
Okay. Position 21, Tom Fowler was a plea. 22 was null pros. 23, Andrew Gordon. What's the situation with Andrew Gordon?
You said he was
released.
Was he released? Yay, nay?
Yes, Your Honor. For a while, Odyssey was showing him as being currently in the jail, but it was updated a few days ago to show that he was released on the 24th.
Oh, wow. Okay. He was released, so this is further notice for trial.
Yes, ma'am.
But when they're released, is it just automatically reset jail jury? Or, well, send back to division?
Send back to division. So jail jury was throwing me off. Sorry. So, Mr. Coleman, the way I interpret, well, we'll go over that later, but right now,
Okay.
Nandy Hamilton,
That's
position 24.
That's a not guilty and waiver of appearance.
All right, so that's waiver of arraignment, further notice for trial, and that would be jail jury, in my book.
Right.
Okay, Shamari Haynes, 25 is a plea, 26 is null pros, 27, Joshua Hensley, which is 27, 28, 29, and those were all waiver of arraignments and further notice for trial jail jury. Position 30, Maurice Jones, 30 and 31. What are we doing?
Your Honor?
Yes, Mr. Bartel?
Yes, we have reason to believe that he may need an evaluation by DBHDD. I'm kind of on the fence by that, so we would ask that it be reset. Well, either SAP or the 11 a.m. calendar next Thursday, the 8th. So Ms. Amin Williams can talk to him as well.
I'm going to reset it to next Thursday, which is August 8th. And that's going to be on the SAP calendar.
Okay.
And if you decide that an evaluation is required, please submit it prior to then so we can further notice the case.
Okay, very well, Judge.
All right, thank you. That's for announced for position 30 and 31. Position 32 is transferred to Superior Court. 33, Chance Matt. What are we doing?
I have that he was released on July 26th, 2024. We would ask that they be reset further notice.
Right, this is further notice for division for trial. Position 34 and 35 were pleas. Position 36 and 37, Timothy McGee. I have
That was
the
Mr.
notice question mark.
He's released.
That was Mr. Ranger's client who was released.
Right.
Oh,
On July 26th, 2024, Your Honor.
all right, so this is released and further notice for trial with division. And 38 and 39 were a waiver of arraignment and further notice for trial. Position 40, Kufu Ray. I have attorney Samantha Adams.
Well, Your Honor, that's my case. Ms. Adams used to be with our office.
Oh, I see, okay.
We would further notice that for a trial. I don't know if he's been arraigned or not. If he hasn't, I can send a waiver of arraignment.
All right, I'm sorry, Mr. Bartel, you're having to bow down. You can sit in the chair right there as well.
You can't see my face here.
But if you sit in the chair, I can see you clearly, but that's okay. But Mr. Bartel, if Ms. Lewis can confirm that he's released, I can further notice this for trial. I'm sorry. Is he released?
No, he's not really. The misdemeanor.
He's not released.
Oh, I'm sorry. What I meant was if you can confirm that he has entered a not guilty plea or if this case has been arraigned. Otherwise, Mr. Bartel, out of an abundance of caution, could you submit a waiver of arraignment?
Okay, I'll do that, Judge. And
All right.
just let the court know he had an evaluation and that came back to where he can go to trial on this.
Okay.
And
So
he has not been arraigned.
Okay, so please
I'll
submit.
do a waiver.
Thank you. This is further notice jail jury. 41 was a waiver of arraignment and further notice for trial. This would be jail jury. Okay, Thornton, position 42 is a waiver of arraignment and further notice for trial jail jury. 43, Tremaine Watts, and I know we just addressed that. So that's
for the private attorney.
He's here now.
He's in front of you, Your Honor.
all right, and we'll be right with you. Position 48, Thomas Weems is a waiver of arraignment and further notice for trial jail jury. Yeah. And 49, Tedrick Whiters is a plea. 50, Williams is a plea. 51, Williamson. What did we do there? Montez Williams. Oh, that was a plea as well. And that was 52 was null prost. 53, Wimbush. What are we doing there?
Your Honor, the state did recommend that for a transfer due to the defendant being a convicted felon at the time he was in possession of a firearm. We are still waiting for, oh, actually, we did receive a order on that case, which I submitted on Wednesday, at 12:19 p.m., but it looks like I did not submit that directly to Ms. Champion, so I am forwarding that order now. So it actually was signed by the DA's office.
Okay. I don't know who's counsel, but Quavo Wimbush case is going to be transferred to Superior Court. 54, Corey Woods, 54 and 55. Any announcements?
Oh, that is not guilty and waiver of appearance.
All right. Waiver of appearance, you'll
And
be
arraignment.
waiver of arraignment and further notice for trial jail jury. Okay, moving back to positions 43 through 47, we have Tremaine Watts. And is Mr. Watts, the gentleman seated in courtroom 2? Mr. Tremaine Watts, my name is Judge Law. Please remember you have a right to remain silent. Anything you say in open court, your statements can and will be used against you. Presently, you have 5 open matters with the State Court of Fulton County. Your attorney is Mr. Mide Oleloye, is that correct, sir?
Yes, Your Honor.
Okay. And Mr. Watts, do you see your attorney on the screen? You need to
Yes.
say yes or no.
Yes.
Okay. All right. His all right. 22 CR 1417B. Mr. Watts is accused of battery, family violence, and misdemeanor obstruction from August 20th, 2021. 24 CR 4875B. Mr. Watts is accused of willful obstruction of a law enforcement officer from July 16, 2024. He has a bench warrant, 24 FTA 979 from May 8th, 2024, and another bench warrant, 24 FTA 980 from May 8th, 2024. And the fifth matter is 21 CR 2406B, misdemeanor obstruction of an officer, misdemeanor possession of marijuana, and loitering or prowling from October 1st, 2019. How are we proceeding in these matters, Mr. Oleloye?
Your Honor, so the thing, this is a bit tricky as I only represent Mr. Watts in one position, which is position 43. However, I did represent to Ms. Lewis that if I can receive an offer from the state, if I could potentially resolve all of them, I'm not sure what the offer is, but I would be open to at least trying to resolve all of his cases today, if possible. But I did want the court to know that I do only represent him on position 43. So if we can have a breakout if possible, so I can speak with him once I get enough.
And if you would be so kind as to put your email in the chat directly to me, what I can go ahead and do is put all of these recommendations into one email to you.
Right now.
Mr. Coleman, I think that concludes the PD's cases. If y'all are y'all interviewing folks in courtroom 2 right now?
I think they're interviewing for a first appearance.
All right.
Well, not in here, not in here.
Okay.
Next door.
All right, let's go ahead and mute courtroom 2.
Yeah, I do have it. Thank you.
All right. Mr. Bartel, have we concluded with all your cases?
Question, the orders for the SAP and the 11 encounter, should I send those to Ms. Lewis or Ms. Champion?
April Champion.
Ms. Champion. Okay, I will, sir. Yeah, that concludes my cases, if I can be excused.
Yes, thank you, sir.
Wait
Thank
to the
you, Judge.
courthouse, so I should have your plea forms to you shortly.
All right, thank you, sir. Anyone, I guess probation has to stick around, maybe victim advocate. We can close out Mr. Bartel's Zoom panel. And we'll be in a brief recess.
Your Honor, if I may inquire, what was the result on position 9, Victor Bryant?
Oh,
I was trying to keep up, but I missed a
that's
couple.
okay.
I'll tell you.
5 cases, I'm
Yeah, that was
impressed.
mine. That was,
He was released and further notice.
no,
still in
he's
jail.
not, yeah,
He's
not
not released,
released.
Judge.
He's
He's still
in
in jail.
custody. It's just reset jail jury.
Oh, I'm so sorry. He's further not released, further notice, jail jury.
Yeah,
Okay,
I did file a waiver.
okay.
I think I'm also gonna have a social worker referral for him too.
All right, so Victor Bryant is not released, further notice, jail jury, possible evaluation.
Right.
That's the announcement. Okay.
Thank you.
Anything else from courtroom 2?
If I could just have a breakout room with
Yeah.
Mr. Watts, they have extended the offer.
Yeah, I just want to make sure there's no other matters before I put courtroom 2 into a breakout with you.
Thank you, Your Honor.
All right. Any other matters, Mr. Tay?
Nothing, may I be
All right,
excused?
thank you. Yes, thank you. Okay, Miss Lewis, please place courtroom 2 and counsel Mr. Oleloye into a breakout session. And Mr. Oleloye, if you decide to move forward with the plea today, then you need to make sure the paperwork is submitted to Miss April Champion.
Okay.
I can move forward with the plea hearing. And Ms. Falk, if you can transmit the plea offer as soon as possible. I want to try to get this done within the next 15-20 minutes so that, and I do apologize, but the courtroom is going to be used for another proceeding and folks need to be released to at least grab a cup of coffee and a quick sandwich.
I did send it. Has it not been
I
received?
have it. I have it. I do have the
Okay,
offer.
great.
All
Okay.
right, we'll
So
be
if I could just get
recess.
in the event that we do resolve today, can someone send me the plea paperwork so I can at least work on that? Or how would the court prefer I
Ms.
get
Falk
that?
is sending the plea paperwork to you at the same
Okay.
time.
Okay.
And you can ask him for express permission to sign off on them. And then you transmit them to April Champion.
Champion.
Or
Okay. Thank you, Your Honor.
whatever the DocuSign feature says, okay?
Okay. Thank you, Your Honor.
Thank you. All right, we'll be in recess until we hear back. Miss Lewis, please place courtroom 2 and counsel in a breakout. Thank you, folks. We'll be in a brief recess.
Judge Law?
Yes.
Uh,
Oh, I lost your audio for a moment.
I said, can you hear me?
Yes, now I can.
Okay, so while I do have you, I would like to make a request. It's from the calendar on July 26th. The defendant was pro se, not represented by counsel, and the state does have a request on that case.
May I have the case number?
Yes, absolutely. I just didn't know if you would be willing to entertain the request at this time.
I won't know till I see the case.
Yes, Your Honor. Let's see. Let me see. I can pull that up so I can present that.
Miss Lewis, are the folks still in the breakout room?
Yes, ma'am.
Oh, okay. Let's see how excited she sounds.
I'm sorry, Your Honor, I just had to pull up my
No problem. Right, Mr. Olelore, are we?
Yes, Your Honor. After speaking with Mr. Watts, my understanding right now, we're gonna maintain our plea of not guilty. I guess we're back in a tricky position, given that I don't represent him on the other cases, but as far as the position 43, the battery family violence, we will maintain our not guilty and just request a jury trial date.
Okay, let me just pull up that case. That was 22 CR 1417B. Would that be correct?
Yes, Your Honor.
All right. And was there any indication that you were planning to represent him on the other cases?
So it would have to go through, I would reach out to Mr. Jordan. I personally don't have any issue, but because of how they assign them, I would essentially have to reach out to Mr. Jordan and then see if that'll be fine. And then
may I just clarify, are you appointed counsel on conflict basis?
yes.
Okay.
Yes.
All right. I mean, I can go ahead and appoint you to represent him on all these cases, and that would take care of that.
Okay. That's fine, Judge.
All right. And in light of that, I'm just wanting to see. So on position 43, a plea and arraignment was conducted and it said waived jury. Are you now asking for a jury trial?
Yeah, I never waived the jury. I just waived the arraignment, Your Honor. I'm not sure why it's listed as waived jury.
Maybe that's fine. So there's been a waiver of arraignment. With regards, did you want to have the same announcement for positions 44?
At this moment, yes, Your Honor.
47 and then the 2 bench warrants?
Yes, Your Honor. At this, we'll keep the same announcement at this juncture.
Okay. And do you have all the case numbers?
I have the calendar, so I can note them, Your Honor.
Okay. It will be 43, 44, 45, 46, and 47.
Yes, Your
If
Honor.
you can file a waiver of arraignment to apply for 44 through 47, and all the cases will then be further notice for jail jury.
Your Honor, if will the court allow me to address bond, if possible?
Ms. Falk, are you ready to address bond in these matters?
I can get ready. That's no problem. I closed out my form because I thought that was all we were doing today. So
Actually, Your Honor, it's my understanding it wouldn't matter because he's actually in on a felony matter, which the bond is much higher. So I'll forego that for the moment because even if you were to lower it, it wouldn't change his status in regards to him being released because he's being held on a felony.
And just to let you know, he's also being held on, just to let the attorney know, he's also being held on 2 probation violations on no bond. Both felony probation violations. So I just wanted you to be aware that it's more than just the open felony.
Okay,
All right, so,
that's fine.
Mr. Leloya, if you can file an entry of appearance on positions 44 through 47, your waiver of arraignments, and all 5 cases are going to be further notice jail jury with the division judge. And that would be Judge Porter.
Thank you, Your Honor.
All right.
Thank you, Ms. Falk.
Thank you.
And that concludes my matters. May I be excused?
Yes, sir. Have a good afternoon. Oh,
You as well. You all as
thank
well.
you. All right, Mr. Watts, that concludes the matter with your cases, and your attorney will be in touch with you. Thank you. Courtroom 2, we are concluded. Thank you. Ms. Falk, did you still?
I have the case number, Your Honor.
All right, I'm ready.
It's 24 CR 00